Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, also of the Mickey Mouse Clubhouse, a small law firm in central Minnesota. Oh, guys, every day's a chore. Every day's a chore. But we are here. We are here. And every day's not a chore because of you. It's not a chore because of this show. It's a chore because of the flipping nonsense that happens every day. Like, why are people like this? Why does this have to be this way? It's because they broke in the brain. They broke in the brain. Oh my goodness. So anyway, I'm ranting. Not really. I'm just marveling. I'm marveling lately at people like Jay Woolman. So I wake up to Kara Edwards like retweeting Mike Dunford. Is that what happened? Is that where we are now? That Kara Edwards is retweeting Mike Dunford, who's busy filleting Sam Johnson for putting Jamie Markey's grandstand speech into his pleading, and then we're all suddenly pretending that Jamie Markey is the hero of all women. Is that where we are? Because I'm pretty sure that's what I woke up to this morning. Something like that. I think maybe I need to double check my posts this morning and make sure that's what I actually saw. Hold on, I'm checking right now. Because, yep. Here, I'll just put it up. I don't like doing, like, hey, let's look at Twitter shows. But let's take a peek at this real quick. Oh my God. No, that's not what I wanted. Because this is where we are. And the only reason I'm bringing this up is because it came full circle just 10 minutes ago or whatever, when I saw the next brilliant clip, or the brilliant tweet. Oh my. Let's see. How do I do? Oh my gosh, my brain forgot how to work this stupid machine. Okay. So here we are. I'll change this just a little bit so it's easier to see. All right. So let's go back. And as usual, the source of the stupid is Mike Dunford. So I'm becoming routinely less and less surprised by the brilliance of Mike Dunford. Really just a great man. So Mike says, Sam, magnificent. What was magnificent? We're gonna go. We'll take a look at this document a little bit later. But this is him. I'm sure Mike has done a 700 tweet thread about this document and all of the others, because and I'm sure all of, like, you know, several people read it. Okay, but that's how he do. So anyway, he's got plaintiff's defense or response to this truth is so shocking that it merits singling out for the nearly page-long paragraph which it hides. If she would, so this is from plaintiff's response. If she was so concerned about her safety and health, and was concerned about the safety and health of what she claims are past and future victims, then why did she wait years to make her statement? This is critical because here's what they're trying to do with this. Here's what they're trying to do with this, and the stupid is contagious all the way into not stupid guys like Jay Woolman. This is the problem with this, okay? Let's pause for just a second and remember the horrific abuse suffered by Jamie Markey at the hands of Vic Mignogna. Because what they're trying to do is make Jamie Markey into the victim of sexual assault. What they're trying to do is equate Jamie Markey to a woman who is trapped in a relationship that is abusive and rapacious, so that she has to face sexual abuse at the hands of a potentially violent and domineering abuser every day. They're trying to equate Jamie Markey with that person. They're trying to equate Jamie Markey with someone whose livelihood is literally in the hands of someone who demands sexual favors or sexual activity from them so they can feed their family or something like that. That's what they're trying to equate Jamie Markey to. But what if true, if we take Jamie Markey at her word, what happened? If we take Jamie Markey at her word, being as charitable to her story as possible, what happened is this. She went to Funimation Studios. Vic went to Funimation Studios. In the lobby of Funimation Studios, Vic walked up to her, hugged her at her initiation, then ran his hand into her hair, grabbed her hair, pulled it, and whispered something sexual into her ear, at which point she, being so afraid and intimidated and broken by this act, shoved him off with a send-off akin to "get the F off me" or something, probably. And then never did that happen to her ever again. Ever. According to Jamie Markey. Okay? If we take her at her word, that is the event. Now, that alone, that's it. No genital grabbing, no fondling, no penetration of any orifices, no forced touching of Vic's genitals, no groping, nothing like that. A hair grab, a tug in, and whispering something sexual. If only one that she was able to defeat with a shove. That's it. And then proceeded to be friendly with him for the next 12 years or something like that. Okay? So again, I'm being fully charitable and saying it happened exactly as she said. And we're supposed to liken this or equate this to a rape victim, to someone whose abuser has power over them, to someone who is unable to speak out because there is a genuine fear of what will happen to them if they say a word. That's what we're supposed to believe. And typically, by the way, that genuine fear is that person will harm my children or take my children away from me. That person will beat me. That person will take away my friends and family from me. That's the fear that real victims of sexual abuse actually face. But we're supposed to equate one hair pulling incident with that. Okay? Because remember, that's the stunning and brave thing that Jamie Markey did. Now, of course, if we take Vic's side of the story, she gave him a hug and he said, "Whoa, hey," and played with her hair a little bit. There's no grab, there's no pull, there's no sexual whisper into the ear. So if we take that, I mean, the abuse looks even more ridiculous. But even if we split the baby and say it's somewhere between that, we're still nowhere near a real victim of sexual abuse in any context. Not even in some delusion of her mind where it's, well, it's in the eye of the beholder. No, not sexual abuse. It's just not. I'm sorry. You may say it's an inappropriate touch. You may say it's a battery that infringed on her personal space. Fine. This is not someone who is at the mercy of an offender who then cannot talk about it out of fear of retaliation. And mind you, the perpetrator was so powerful that he was undone by, according to them, mere tweets from an anonymous person on Twitter a decade removed with no solid accusation. That's just how stunningly powerful he was. But I digress. Let's move on. Why would she wait years to make her statement? And remember that Jamie's statement was how she is standing up for women and all of these blah, blah, blah. But she also states that she knew it was going on, but then she didn't know it was going on. And when she found out it was going on, even though she knew it was going on, that suddenly she had to stand up for all the people who this was happening to. But let's go. Of note is that plaintiff here admits that Jamie's statement does concern health and safety. But merely criticizes how long it took her to speak out. Sam, I don't know that you want this to be about health and safety, because then it's a matter of public concern, which means you don't get truth as a defense. I don't know if you realize that, but that's what you're up against. This is neither a factual nor a legal argument from plaintiff, only the retort of a person so bereft of empathy and humanity that they would rather shame a victim for her trauma. For her freaking trauma? Are we serious? Are we serious here? Okay. Then engage in the discourse expected of parties and counsel involved in litigation. You're right, Sam. What he should have said is, in litigation, plaintiff should have said, I understand and respect her trauma suffered at my hands. And she is correct that this is an issue of health and safety involving my transgressions over the years that I will now admit are true because she said she was traumatized. What the hell are we talking about? In hostile litigation involving adversarial parties, Sam Johnson is demanding that the other party acquiesce to trauma that he does not believe occurred and does not admit to causing through acts that he says he didn't commit. Right, Sam. That's what he's supposed to do in an adversarial thing. And Mike fucking Dumford, the dumbest guy I can see in all of this, is just parroting along. Happy. Yes, that's what. Yeah, brilliant, Sam. Good job. Let's forget that we're in an adversarial process where the two parties are supposed to present their opposite cases because any talk of settlement has broken down, and they're not supposed to give really an inch to the other party if they don't have to. And they only have to if the other party has presented an ounce of truth. An ounce of truth, but they're asserting it's a lie, Sam and Mike. They're asserting it's a lie. So demanding through some bizarro world of legal pretend that the other party must acknowledge with empathy the trauma that she didn't suffer. Again, Whether you believe she suffered it or not, Vic's position necessarily is that she couldn't have suffered trauma from an act he didn't commit. Right? How is he supposed to empathetically acknowledge the trauma he didn't cause because it didn't happen? What, even if you don't believe Vic, the position that this is what he's supposed to take is ludicrous. Even if you think he's a lying scumbag, you have to know that his lawyer and he must take this position because it's adversarial, and to take another position would be to admit guilt to something he says he's not guilty of. Jamie's statement was made well before the specter of plaintiff's lawsuit and his $250,000 war chest helmed by a faraway alleged Minnesota attorney hung over her head, and in it she stated her very clear and unequivocal purpose, which is certainly worth reiterating in this reply. But in this moment, I want the others to who I know are out there to hear this. Who I know are out there. How do you know they're out there? You are not responsible for what happened. You do not have to be dismissive, ashamed, or afraid. Also, I hope if anyone ever goes through a similar experience, they will know from the start that their body is not up for debate. Like, what is she even talking about here? Their body is not up for debate? No one's debating your body except when we call you fat, okay? Like, no one's debating your body or your bodily integrity or your right to not be abused. People are saying you weren't abused because you lied. There's a big difference there. This isn't about bodily integrity. It's not about the sanctity and security of oneself or their need to be safe. No one argues with that. Everyone says specifically, Jamie Markey, you are lying, because a lot of this story, basically all of it, looks like a lie. You can't produce the facts. You can't say when. You can barely say where. You can't even say what happened. You're lying here. Oh, and it was so long ago and so vague, and you waited and no one reported anything, and your reasons for not reporting it are all too convenient. They're saying you're a liar. Not that people don't have a right to be safe. But here they are. Here these guys are so afraid of the notion of the feminist machine. They're so afraid of that they're willing to set aside their profession. Jay Woolman is not a stupid attorney. Mike Dumford is, but he's still allegedly an attorney, right? I get to say that, don't I? That he's allegedly, they get to set that aside, pretend like defending your client doesn't occur, and pretend like people don't get falsely accused of things literally constantly. And that person has no right to a defense, but that because someone alleges trauma, that the person must acquiesce to the trauma that's alleged, whether or not it happened. This is how far sunk people in the legal profession actually are. That they forget that there are two sides to the story, and one of them is necessarily alleging the other is a liar. Okay. Also, their body is not property of the most popular person in the room. When in God's name did Vic declare Jamie Markey's body property? Or did anyone suggest that? The only person who seems to be suggesting it, if we believe women, but notice who's not believing women right now. Jamie Markey, Monica Rial. Why? Thabit's my friend, right? So he must not have done it. I can't wait. Oh, I can't wait for Jamie Markey, Dominique Skye, Monica Rial to start slut shaming, denying, and disbelieving women like Stephanie Nadolny. I can't wait for that hypocrisy to come out. I bet it's already happening, right? I bet it's already happening, but I can't wait for it to come out in public. Because they're lying. It's never been about sexual assault. It never has. not with Vic. Their body is not responsible for a company or a show or an art form. Well, actually, here's the weird thing. Some of their bodies are responsible for a company, a show, or an art form when they make that choice to do that. That's actually a thing that happens, so that's not true at all. Their body is most definitely not responsible for the reputation and livelihood of a predator. And again, no one ever said it was. They're just saying you're lying. Plaintiff would have been better served by not responding at all. Oh yeah, there you go. That's how it works. That's how it works. Mike, Sam, magnificent from Mike Dunford, quivering Mike. Oh my good God. And then retweeted by Kara Edwards, someone who is shown to have falsified the events in her own affidavit, mirroring Jamie Markey's, and then the photo came out, posted by someone else who lied in their affidavit, Mary Reese, posted to her Facebook in a happy way as friends with Vic Mignogna. When they actually unearthed the actual post, it shows it all to be a lie. All of it. Oh my God. And then of course, you know, Marky Mark's response to the TCPA motion. This page is so important. Yes, I'm personally invested, and quite frankly, we all should be at this point. What message should we send our children? Clearly that lying about an event a decade ago is proper. That's the message. That's the message. And sweetie, the receipts have been produced, and you know it. And you know it. That's the worst part in all this. You know you've been had on this. You know you're lying about it. And yet you persist. And yet you persist. Please read the final paragraph of the page from Jamie herself, heart. And then, of course, and everyone clapped. Because that's what it is. That's what it is. That's what they're demanding. Bravo. Bravo. Stunning and brave. Stunning and brave. You really helped all those alleged victims by not saying anything sooner. So brave. So brave. All right. I have another response to this. Okay. This is what I'm getting to. This guy, Nick Rekieta, what's the tea? Well, it's Milo, sweet tea. I don't quite understand the latest happenings. They said, oh, they suggested that these people waiting a decade to come forward is somehow not absurdly suspicious. Notice what's happening there. These people waiting a decade to come forward is somehow not highly suspicious. Now, let's move on to the hot take. Hot take from Jay Woolman. Nick, it's pretty common, actually, for victims of harassment or assault to fear publicity and retaliation. Do better. Jay, actually, I'm talking about specific people in a specific case who have been shown over and over and over and over again to have lied. Over and over and over again to have lied. To not only have lied, but to, if we take their stories as true, enabled abuse, endorsed abuse, hired abuse, continued to support abuse of other people, lied to cover up abuse for no reason. For no reason. If we take them at their word, that's what they did. If we believe Monica Rial, if we believe Jamie Markey, then they not only didn't report the abuse, they rubber stamped it over and over for no reason in an industry where there is someone around every single flipping corner and has been for this past decade. There is help everywhere, anywhere. None of them even reported it and went so far as to not tell other people when given the opportunity, and that's only if we believe them. If we believe Monica Rial, after Vic assaulted her in a hotel room, after she was rescued by Stan Dolan, who denies all of this, after she then went to dinner with Vic, she then went back to his hotel room for no reason she or anyone else can articulate, to then, for another non-reason, talk to Michelle Speck and lie to her face about what happened. What power did he have? What power did Vic have over Monica Rial to do this in 2007? What power? What power could have been produced to not only sexually assault her by luring her into a hotel room with a video, with promise of a viewing of a video she was flipping in, then to sexually assault her and to cause her to not make any resistance? This is Monica in your face Rial, right? Voices Bulma, voices all sorts of tough in your face characters, acts tough and in your face all the time. This is Monica Rial. So this is her being allegedly sexually assaulted in a hotel room, freezing up, not saying anything, not resisting, not doing anything. Okay, I'm going with you. Then being rescued, praising her rescuer in her own thing. He could see the concern on my face. He immediately asked, "Is Monica okay?" And then they went to dinner. She was rescued. She's removed from the situation. And then immediately and without explanation returns back to the exact same place to take a phone call on a balcony to Vic's fiance to then lie about what happened. That's it. That's what we've learned. What power did he have to cause this? It's amazing. It's amazing. Jamie Markey allegedly assaulted in public, allegedly assaulted in public, surrounded by friends, by a man who does not live or work in the building where she was allegedly assaulted. Just to be very clear, at the time of Markey's alleged assault, Vic Mignogna lived in LA, 12, 13, 14, 1,500 miles away from Dallas, right? Lived over 1,000 miles away, recorded remotely, never came in. What specter of fear is she under that she couldn't say something to literally anyone? Not her friends, not her trusted writing partner. No, only later. Only after Jesse Pridemore tells the same lie. Only then does this story come out. And only once one repeat liar like Jesse Pridemore comes out with a story does suddenly everybody come out with the exact same story. Jay, I get it. You're not following this case. I know you're not actually following the case. Maybe you read pleadings here and there. That's great. But I know you're not familiar with actual facts of this case and what has actually been exposed. So I'm going to cut you the benefit of the doubt here. They are lying. Not only are they lying, they're also being specifically accused of lying about someone. So all of this is ludicrous. Because if we break it down to just the legal realities here, of course Vic had to take that position, and taking his opponent's position would have killed his case, and you know that. But of course he has to take that position. But Jay, bruh, she's lying. I'm not talking about other women. I'm talking about these women who very much appear to have engaged in a civil conspiracy to ruin a man's career because, let me Let me pause you for the revelation. They don't like him. Not because he's a danger, not because he sexually assaulted him, but because, and I quote, he's an asshole. Jay, he's not in the friend group. That's it. He's not in the friend group, Jay. And trust me, when you look at this disgusting little den of Funimation employees and contractors, you'll learn very quickly that not being in the friend group is far worse than being a sexual assaulter, because the sexual abusers are in the friend group and they're still there, Jay. They're still there. And they're in positions of actual power. And all of them know it. And I can't wait to tell you about it, Jay. I can't wait to tell you about it. By the way, if you're one of those people at Funimation that's gone quiet because of your, not because of your position on Vic or something like that, but you've gone quiet out of fear for your own bad acts. And by the way, there are high up employees at Funimation who have gone quiet out of fear. I'm gonna tell you now, a reckoning is coming. It may not be from me, but the eyes on this case and this situation, even if, let's be real, let's say Vic goes in on Friday and Judge Chup throws out the case on Friday. That is one of the least likely outcomes, that he flat out throws out the case on Friday. If anything, he'd wait and rule on it within his 30 days and fine. One of the least likely outcomes is that he rules to throw out the case on Friday. Flat out. It doesn't matter. A lot of people are looking at Funimation right now and looking at the actual evidence of predators. If you're out there and you're keeping quiet, you may want to get ahead of this story. I'm just telling you, because I've already got people telling me who you are. And if they're telling me, they're going to tell the next guy and the next guy and the next guy. And believe me, it's coming. Oh, and if you think you're safe, you think Sony isn't already sharpening the axe? You think Sony isn't already sharpening the axe? You know people know about this. The environment at Funimation was such that it encouraged it. Tell the story. Talk to me. Tell the story. Help me tell the story. I know. Listen. I know many of your stories, and I know many of your stories are a result of not actual abuse. I know, but I can't tell that story without confirmation. So help me tell the story. I know it's the environment at Funimation. I know you were in a sexually charged environment. Sexuality, affection, inappropriate touching, sitting on laps, grinding genitalia on people, creeping on people, flirting. All of that was not only encouraged, it was essential to advance. I know. Now help me tell that story. Because just imagine what happens if it's the wrong person telling me. Help me tell that story. You know who you are. And I know there's way more than one of you. Let's not be pretending. I know there are real abusers there, and I know there are people who are in there, who are where they are today and did the things they did because it was a sexually charged environment. You guys are a kind of victim. Help me tell the story. Jay, you're a fucking idiot. You're spouting off about something you have no idea about. They're the people who are terrified, who are victims, who are terrified to come forward. They're really there. They're still there. They're still there. And their abusers are still there too. And the people you're talking about now are covering for them. And it's sick. Good job being on the right side of history. You're literally supporting the people covering for abusers. And by the way, Jay, this is it's a real open secret. Not a pretend open secret. And we're not talking hugs at conventions and kisses on foreheads, Jay. So, with respect, fuck off. That said, Jay, thanks, you're right. It's no longer suspicious at all. Your tweet changed all of the facts of this case because of general statements about other people. Brave. Very brave. Very brave to do that. Oh, and by the way, Jay, a person who said that this lawsuit was frivolous and worthless and all of that. This lawsuit, by the way, has brought people out to start exposing actual sexual abusers still employed at Funimation with massive amounts of power. And the company's covering it up. And they don't have an HR department. Oh, and by the way, the alleged sexual abuse of Chris Sabat, right? That's bouncing around right now. Guess who the HR director at Okratron Studios is, Jay? It's his fucking wife. How do you think HR complaints go at Okratron, Jay? When the abuser is the CEO and the HR department that you would report him to is his wife. I'm sure they're great. Keep it up, big guy. You know what's going on. How's that Alex Jones case coming? I'm sorry. I'm mildly irritated. I'm mildly irritated by this stuff, right? Because it's coming out. So anyway, Stephanie, Nadolny, I implore you, please, come on the show. Tell your story. I'll give you the platform. I'll give you the platform to tell that story. I have questions. I have questions of you. I'll be fair. You know what the questions are. Come talk to me. Don't let other people tell your story. And to the other victims out there, come talk to me, please. I will give you the floor. Tell it. Many of the victims, many work at Funimation, but some don't. Some have been thrown out, not only of Funimation, but the industry. Come tell your story. I will let you tell the world. They can't silence me. They did silence you. But they don't owe me anything, and I don't owe them anything either. Come tell it. Come tell it. All right. All right, I'm simmering down. Okay. So, now to reel that back in, I was gonna open the show with Meyer versus Waid. there's a document that came out a little bit ago. Let me just make sure. I don't think anything came out today. Oh my goodness. I didn't expect that. Right? That was not in the plan. That's not in the show script. The show script. Here's my show script. That was not in the show script, so I didn't expect that. I just I was just mildly annoyed. But then I thought about it as I was talking. Realized I'm a little more than mildly annoyed, I guess. While I'm pulling this up, I'm going to do some chats here. Okay. I think I've got this document. This is actually filed on September 28th. With all the Vic stuff, I just hadn't gotten around to it. And we're not going to go through this whole document, okay? I don't want to... Where are we? Here we go. We're not going to go through this whole document. This is defendant's reply in support of motion to dismiss first amended complaint for lack of personal jurisdiction. So, of course, your boy Zach gave his response to the motion to dismiss. What's up with the L's? I missed it. Oh, thanks, Unreal Int Gaming. Oh my goodness. Yeah. So your boy Zach filed his response to the second motion to dismiss for lack of jurisdiction, the second ill-conceived motion. And now, of course, Mark Waid has responded. So we're going to take a skim through it real quick. But first, I said chats, and I meant it. I meant chats. So we've got Arctic Pride says, "Damn it, Nick. Every time I type consult into a patient's chart, I have to double check to make sure I haven't written... Oh, consult! Even I did it. I have to make sure I haven't written conslut. And every time I do, I hear it in Lemoi's voice. Thank God I haven't saved it to anyone's records yet." Well, at least it's a... You can say that's a transposition error. You're just typing too fast. Too fast. Wes Nile Chan says, "Hey, chat, I need a bit of help picking tonight's game. Press 1 for Legend of Lemois, Mosquito's Masks, or press 2 for Legend of Lemois, the Wind Taker." Mythos Irving. The Sheepdog Ron, he attacked with a remote. Good boy, Ron. He's protecting Monica from V-Bad-Man Vic. But Sabbath is okay to plow his mon as he carries snack tray. Hashtag funny casting couch. Nothing funny about it. Name says, "The last time Ron was involved in an anti-slap lawsuit, he was ordered to stop slapping the skit out of his wife and kid. Plot twist, it's Arms Girl who secretly pulled air from across the room in the weirdest frame job ever." Ryan Mercado says, "Guess who Sam Johnson compared Vic to? He actually compared Vic to Harvey Weinstein and Jeffrey Epstein when he made his public figure argument." Oh, of course he did. Of course he did. Despite Vic not actually having casting authority or any ability to advance anyone's career, other than being next to him means more people are around you who might also pay you. That's it. That's it. Tucker says, "So he's suggesting that Jamie Markey has the relationship with Vic that Sabbath actually has with women at Funimation? That's a fail." Mithran Emmer says, "Law Twitter, like others who live on social media, cast aside common sense and integrity to spend all their time huffing their own farts and getting high off of the fumes." Smiles DeCat says, "Finally got a chance to watch your stream live and in full and not needing to play catch up. Made a Twitter just to watch this degeneracy unfold. Take my Fujoshi money." Hey, thank you. Thank you. Welcome to the show. Tucker says, "Empathy and humanity. Where was the empathy when they tried to push him to suicide? God, how is any of this allowed? This is Dems freaking out about Kavanaugh getting angry at being called a rapist all over again." Isn't that amazing? They're so out of touch. They're so out of touch with where people are. How dare he break decorum and get mad? Oh, right. You just call him a rapist over and over and say it. It's completely false. Say it over and over, though. To everybody in the world. Let's see. F application of self says, is it Fapplication of self? I like that. "A former funny employee told ANN that Schemmel made more than one of those bullying videos like the anti-Vic one. Uh-oh, Sean, looks like Funimation might be looking for a scapegoat. Tokyo 2020 would be awkward with a homophobic mascot." Devil Hunter Nero says, "Nick, can we all agree that Mike wants to apply the sacred ointment to Sam? Clearly it seems that way." Sorry. Appears so. Guys, I actually caught and killed the fly earlier, and now there's another one. I hate him. I hate him more than anything. Hold on. Ah! Curse you! Okay. DCV Titan says, I thought Jamie's purpose was that she wanted Vic's head and balls. Oh, I mean, let's ignore that. Let's ignore that whole thing. Which I think is code for she wants Vic balls deep. Whoa. Now for the usual. Hi, transcriber. Your boss paying you. Is he paying Jadolf? What happened to Casey? Casey's alive. That's why I put him in the thumbnail. Casey still lives. Casey yet lives and breathes. Yet lives and breathes. I've been trying. Oh, here I am devolving into eating nerds. I apologize for what's about to happen. I've been trying to find out if Casey is still alive. I did confirm today that Casey yet lives. Thank God. I was worried about him. I thought maybe he was a dried up husk that Lemoyne was sucking the blood out of to try and combat the West Nile. But he lives. That's why I put him in the thumbnail. Oh my goodness. All right. Tucker says, these feminists are evil. Period. Evil. They want totalitarian control over both men and women. They want to leverage their sexuality to get gratification and call us evil when we want the same and accuse us of abuse after. Can't disagree. They've weaponized sexuality in a way that is I mean, comparable to the weaponized sexuality that they're railing against in the patriarchy, right? The pendulum has swung in the opposite direction. And they found out that they can, I mean, oddly, like it's been a running joke that women can weaponize their sexuality to have power over men for a long time. It was like a meme. But now they're taking that a step further and making it, and like, not that a woman can have influence over a man using sexuality if she, which of course several decades ago was a power move by women, right? Women like Marilyn Monroe, stuff like that, where they owned the sexualization of themselves and took that ownership and used it to empower who they were, right? And that was the whole, I thought that was like the whole last wave of feminism was owning themselves and using that in a positive way. But I don't know, maybe I'm wrong on that, but now it's further. It's not just sexual empowerment, it's sexual control over all aspects of sexuality, to the point where we're literally talking about revoking consent after the fact. Brian Duick says, Nick, stop with the dried up husk jokes. I laughed so hard my asthma made me wheeze. Oh, I'm sorry, friend. Okay. So anyway, let's that rant derailed. That's fine. Let's take a look at this document real quick. So, defendant Mark Waid files this reply in support. Man, he's throwing paper at this case. Just throwing paper all over. Yeah, the last wave of... No, I'm talking about the feminism of equality, and we're talking probably the feminism that was dying about the time I was born. But, you know. Defendant Mark Waid files this reply in support of his motion to dismiss plaintiff's first amended complaint for lack of personal jurisdiction. This round of briefing has only further highlighted two fundamental problems with this lawsuit. The court lacks jurisdiction over Waid. And B, plaintiff's claims are completely meritless, but it is point A that requires dismissal at this juncture. Among other things, plaintiff who publicly advertised he was in New York during the relevant time period. Publicly advertised. His Twitter profile said it. Probably from a setting he put on there who knows when. Now, notice they haven't put a tweet out with Meyer saying, I'm in New York, wink, wink, that's where I live, wink, wink. All they can produce is that at some point, Twitter had Meyer's location in New York. That's all they can do. He's publicly advertising he's in New York, as if he put it up on a webpage and said, you can find me in New York. God, During the relevant time period, neither shows nor even pleads Waid knew that plaintiff resided in Texas or that he would suffer the brunt of any harm there, thus conclusively defeating jurisdiction as to each of his claims. Waid respectfully submits that this jurisdiction issue must be correctly decided at this stage. Otherwise, the parties will engage in time-consuming litigation only to have the Fifth Circuit find the case could not be litigated in Texas at all. Yeah, right. I'm sure that's what's going to happen. I'm sure this will get... They've just forecast it, by the way. When they lose jurisdiction, and they're going to lose jurisdiction, they're going to appeal it. They're going to appeal it. They're going to drag this jurisdiction fight out for another year if they can. That's the sound strategy of Mark Zaid. Drag it out, dry the funds up, make him pay. Make him pay for... I wanted to interfere with his contract and he wouldn't let me. Now make him pay. Court lacks personal jurisdiction over Waid. And see, he's citing the case. He's citing the case that not only the opposing party has cited, but the magistrate judge agreed with the opposing party's reading of the case. So good job. Good job. This is the same stuff, right? They're rehashing the exact same arguments. He had to know that he was in Texas. No, that's not how it works. It's not how it works. You just have to direct activity into the forum. You don't have to know what forum you're directing activity into. Just did you purposefully direct it to the forum? They're really trying to be pedantic on what this means, but it doesn't mean what they're saying. Plaintiff cannot establish personal jurisdiction as to his defamation claim. Same thing. I'm going to guess the magistrate judge is going to look at this and make a recommendation that Texas has jurisdiction. Discovery also established that plaintiff's lawsuit is substantively meritless. An argument that was completely rejected by the magistrate, by the way. So there you go. Good job. So this is the same stuff. There's no evidence. It's just 13 more pages of Ryan Pierce really trying to make a stinker of a case into something. They know that if they lose here, they now know that they can't file a TCPA because they're in the Fifth Circuit. Fifth Circuit said, nope, no TCPA in these diversity cases. So boom, you're out. They know now that they're screwed. I think they're still going to file the TCPA, by the way. Even though the Fifth Circuit Court of Appeals said that that it doesn't apply, they're still going to file it. And if they do, they should have to pay attorney's fees for filing a frivolous motion. But I think they're still going to file it because they're going to argue, well, the court said we could do it. They're going to ignore the fact that they've delayed this so long that a decision went against their ability to file it. But I bet you anything, based on how they've made this jurisdictional argument, that they're going to argue, the court said we could file the TCPA 14 days after, and they said that before the Fifth Circuit ruled against it, so we want to file it. I think that's a terrible decision. I hope to God I'm wrong, but I think they're going to do it because they want to cause as much cost as possible. So then Meyer's going to have to fight it. He's going to have to incur funds to fight it. And since then they'll argue that they can't be sanctioned under the TCPA for filing it frivolously because the TCPA doesn't apply. Or something ridiculous. Because that's how this case is going. It's so freaking stupid, but that's how it's going. Dysrhythmia says, buy yourself some cough drops, Nick. Doing the Lemoyne voice last night must have been hell on your throat. No, his voice actually isn't that hard to do. If I did it properly, I'm secretly gonna work on a more accurate Lemoyne impression that's garglier and less breathy. Because, I mean, his lung just doesn't seem like it'd be able to sustain it. But you know, that one probably will kill me. Billy the Mac says, Your Honor, I didn't know he lived in Texas when I shot the gun. LMAO. Yes, exactly. Literally exactly that argument. That is exactly the argument. Tucker says, isn't there some kind of rule against rehashing the same rejected argument again and again? I mean, there's not a rule against it. It's just not advisable. Okay. All right. So I'm not going to, like I said, I'm not going to sit and dwell on this document. And let's, I got to make sure there's nothing new on Research Texas. I mean, there was something new on Research Texas today. We'll go through that. I got to make sure there was nothing else new. I think there might be. Where's my Discord? Hold up. Getting everything ready. Okay. Yeah, so the letter to Judge Chupp is new. I've got that. Somewhere. Didn't I save it? No, let me just get it real quick. This is pretty pointless. This is just them. I mean, it gives us kind of an insight into how they're framing some things. And we'll take a look at that. And then we'll get into some discussion on their other paperwork still from yesterday. Because a whole lot was filed yesterday, right? So we'll take a look at Sam's thing. By the way, for all of the bluster, Sam does seem to be a competent attorney. I mean, I think that was a little melodramatic in his motion documents there, but Sam does seem to be competent. And I guess Volney kind of seems to be competent too. I think they're dealing with some real problematic realizations. Yeah, I didn't go over Meyer's document. It's the same thing. It's the same arguments. I'll show you the subheaders here. Hold on. I don't really want to read the same arguments over and over. Plaintiff failed to establish jurisdiction as to the tortious interference claim. Okay. Does not even attempt to establish that he lived in Texas during the relevant time. For all anyone knows, he only moved to Texas right before he filed this lawsuit. Yep, there you go. That's true. That's definitely true. Actually, I think you can do that. But they've only asserted in their arguments under oath that he's a Texas resident, that it's a Texas contract between two Texas residents. So, in any case, under Fifth Circuit precedent, Wade's lack of knowledge and regard conclusively requires dismissal of the lawsuit. It's the same arguments. Calder, Revel versus Lidov, same things. These are just more citations of the same stuff. Explaining specific jurisdiction tests regarding intentional torts involves showing that the tortfeasor knows that the brunt of the injury will be felt by a particular resident of the forum. Meyer is a particular resident of Texas. He is a particular resident of Texas. He knows that the brunt of, the brunt of the injury will be felt by a particular resident of Texas. He's just claiming that he didn't know it was Texas. That's not the test. It's never been the test. Because defendant not know where plaintiff was located during their communications. Defendant's conduct was necessarily not purposefully directed at Texas. This is Rad versus Bragg. Again. I guess we could look into this. We could look into this case, but it's the same stuff. And this is district court rulings that are likely narrow and have nothing to do with this case, because all of the case law supports that if you purposefully direct your activity to a forum, that you are hailed into court in that forum. Of course. And the magistrate already dispensed with this argument. Finding no jurisdiction where plaintiffs failed to establish a prima facie case that defendant knew the plaintiffs resided in Texas at the time of defense, allegedly tortious conduct. But they have established a prima facie case about this being a Texas contract. They have actually established that just fine. Plaintiff does not even address the Fifth Circuit president or the principal requiring that he show that Waid knew he lived in Texas, because you're distorting what they mean. So anyway, what's the next one? Plaintiff cannot establish personal jurisdiction as to his defamation claims. Same thing. Still does not establish jurisdiction as to the Houston claim. Plaintiff baldly asserts knowledge of his Texan citizenship is not required for this court to assert jurisdiction over Waid's defamatory statements made in Texas. Absolutely true. In Texas, to a Texas audience. Literally, the brunt of the harm will be borne in Texas to the people listening. You know. And it also happens to be where the question you have to ask is, what's the alternative? They're arguing that it should be in the Southern District of California, if I'm not mistaken, or whatever district Mark Waid lives in. That's the alternative argument, because somebody has jurisdiction. So what they're going to argue is that California has jurisdiction over a California resident reaching into Texas to interfere with a Texas contract between two Texas residents. California has no interest in protecting a Texas lawsuit or Texas residents. Of course they don't have jurisdiction, or of course jurisdiction doesn't make sense. The only thing they would have is personal jurisdiction, but I don't know that they would even have subject matter jurisdiction over that claim. Same thing, Calder. Same citations from before. Alternatively, the court should exercise its discretion and decline to keep only the Houston defamation claim. Even if the court were inclined to find jurisdiction as a defamation claim based on the Houston statements, court need not ultimately decide that issue. Rather, the court can and should still find that the situation would not justify the exercise of jurisdiction. Fair and reasonable factors do not support jurisdiction over such a narrow slice of plaintiff's claims, particularly since the Houston-related defamation claim is based on events occurring after AP decided not to publish plaintiff's book. See, what they're doing here is they're doing another thing too. They're requiring them to prove jurisdiction and prove all of this stuff rather than make a prima facie showing, which is, again, it's the same thing that they're trying to do to Vic. Prima facie. That's it. Prima facie. Mark Waid doesn't get to controvert his knowledge of where everybody was because the plaintiff bears the burden of making the prima facie showing. That's it. Prima facie showing is that Mark Waid dialed a Texas landline phone number to a Texas company and talked to people in Texas who he says he knew. Prima facie case that he knew it was in Texas, period. It's done. It's done. I just... Here's why I'm not going through this, because it's the same thing. But I just wanted to point out that this happened. So, discovery also established that plaintiff's lawsuit is substantively meritless, which is, of course, is absolutely not. It's darn near textbook TI case. Darn near textbook TI case. The only thing they don't have is Joe Dunn saying specifically, I definitely did this only because of Mark Waid. Okay. White Alakazam says, first live show, so first super chat. Hey, thanks, buddy. Keep me entertained while I'm on forced vacation due to the hurricane. Oh, man. Good luck. Will K says, where is my Monica Jellybean t-shirt? You're on fire. Monica is scared. Ron is going to destroy her for effing Vic. I hope see you next Tuesday. I hope that see you next Tuesday is ground to dust. So there you go. Yeah. So again, 13 pages, and my blood pressure is gonna go through the roof if I keep reading this. Let's look at this instead, because that'll be better. Oh my. Oh my. Oh, I do need to address one other thing. Someone Someone sent an anonymous email to Jay Sean Lemoyne today and me. I don't know why they included me in that. I don't know. The person was screaming at both sides about filing too many documents, and it was all it was not a hostile email. It was clearly just a harassing, and I don't mean that he's the legal definition of harassment. I mean mild annoyance, okay? A mild annoyance email going on about how much everybody was filing and to just shut up and take it to the hearing, and if they don't, they're gonna I don't know, do something, nothing violent or anything like that. I'm not making up a fake death threat or something. This was nothing threatening. But I just have to address this, I suppose. Miss me with that. I don't care about your weird issues with Jay Sean Lemoyne, with Ty, with whoever. Don't email me that crap. I don't care. But I would humbly request, if you happen to be someone I have any influence over at all with my magic puppet strings, don't bother anybody. As I've always said in this, don't bother anybody. Don't waste their time. Don't send them anything. Just don't do it. It's such a silly waste. Laugh at people on Twitter. Laugh at Jay Sean on videos and live streams. It's great. That's great. Don't go wasting the man's time with the stupid email. And that's all I'll say. Oh, and if you're from the other side, how dare you threaten me and my children? And I'm in fear for my safety. But only if you're Kick Vic. There. So here's the letter from Jay Sean today. Here's a letter from Jay Sean. Oh yeah, I'll address the fake GoFundMe in a little bit. Let's see. Dear Judge Chupp,
I write on behalf of Monica Rial and Ron Toye to provide you courtesy copies of the following in preparation for the motions to dismiss pursuant to the Texas Citizens Participation Act that are set for hearing on September 6, 2019. We provide you 4 binders full of women. We have binders of con sluts, along with a thumb drive with the same relevant files segregated by name and file folder.
This just in, Jay Sean Lemoyne is pro-segregation. Here it is, right here. Right here. Pro-segregation. Jay Sean Lemoyne, Wick Phillips employee, Wick Phillips Jr. associate, or whatever. Jay Sean Lemoyne here endorsing and supporting segregation in 2019, in current year, segregating openly. Okay. Black binder immediately segregating out by color. Oh my god. Oh my god, Jay Sean, what are you doing? You disgusting bigot. So notice his first tab is plaintiff's first amended petition. Tab 1A, here you can see the framing starting already. Proposed second amended petition. Not actually proposed, it is an amended petition. According to the rules, they don't need to request leave of court to file this amended petition. So I did a little bit of digging, and there's Rule 63 permits amendment up to 7 days prior to trial. There is case law out there suggesting that a summary judgment hearing is a trial in the meaning of Rule 63. There is not really case law out there suggesting that the TCPA is a trial within the meaning of Rule 63, that a TCPA hearing. There is for summary judgment. There is not for TCPA. So then the question of, is a TCPA hearing like summary judgment enough to make that rule matter? There's no direct case on it. So according to that, with absent language from the statute specifically saying it, and there are decisions out there that say that a whatchamacallit, TCPA hearing is not a trial, not under Rule 63. I don't think there's case law in point for that, but they do say that the TCPA hearing is not a trial for evidentiary rules, because at trial you can call witnesses and stuff like that. So we'll see. Okay. But this is where they're framing the argument that it's a proposed second amended petition, but it doesn't appear to be proposed. It appears to be good. What was I going to do? Oh yeah. It's time to pour a drink. I've got this. I don't know if you guys can see this. Yeah. Vaimana. This is Tahitian vodka. It's made from this is the pineapple and ginger, I believe. Maybe it's just pineapple, but where's my... Okay. I'm going to drink some Tahitian vodka here. I've had this for a long time. I got this in Tahiti like 5 years ago. Still actually good. All right. Is that a fly on the bottle logo? No, I think it's supposed to be a flower. That's actually quite smooth. I've forgotten about this. It was sitting in a cabinet in my house. Okay. All right. Plaintiff's motion for leave to file late response to defendant's TCPA motion is dismissed due to technical issues. All of their responses. Funimation's joinder and joint response and cross motion to strike. Plaintiff's motion to strike to disregard defendant's late filings. Monica Rial and Ron Toye's response to plaintiff's motion to strike. Funimation's response to plaintiff's motion to strike. Plaintiff's response to defendant's TCPA motions to dismiss without exhibits. Oh, that's another thing. They didn't include the exhibits in the proposed second amended petition, which is fine. That's a lot, right? It's like 500 pages. Let's see. Monica Rial and Ron. Wait. Defendant's omnibus objections to plaintiff's TCPA evidence. Plaintiff's objections to and motion to strike evidence offered in support of defendant's motion to dismiss and defendant's supplemental evidence filed in support of defendant's TCPA motion to dismiss. So this is all the crap that they filed yesterday, basically. And then defendant's proposed corresponding orders in Word for tabs 2A, 3A, B. Yeah. So they've got proposed orders set out in there. White binder, which I hear from Jay Sean that he favors the white binder over the black binder. But I mean, that's just what I've heard. That's just what I've heard. Absolutely terrible. Terrible human being. Markey's, so this is all Markey's motion to dismiss, her reply in support of her motion to dismiss and her proposed order. Blue binder, Funimation. Green binder, Monica. I guess Toye doesn't get his own. Oh wait, Monica and Ron's. So they made one mega binder here for the judge, and then they made 3 individual binders for the judge as well. So there you go. If they give the judge a binder, of course, Ty and company can give them a binder as well. This is not interesting, but this is what happened today. So we'll see. Okay, what else is going on here? What do we need to cover next? Okay, we've got Should we check out Marky's stuff here? Hold on. What? File's been damaged. Oh god. Hold on. Where is it? Where is it? But okay, I'll just re-download it then. This is how my life goes. Yes, replace it. Here we go. All right. That was fun. The tech issues, like, it's God's cruel joke these days. What? I don't want that. I want this and this. Thank you. Thank you. Control Alt Delete. Yeah, I just deleted System 32. That should fix it. That should fix it. Defend it. The fly is right on top of the monitor I'm reading, right above the document. I have an ultra wide monitor that I'm reading this document off of, and the fly is over the part where the document is. Oh, you scumbag. Land. Ah! I touched him! I touched him. Now he's been Me Too'd. Or wait, I'm gonna get Me Too'd. Defendant Jamie Markey's reply to plaintiff's response to defendant Jamie Markey's motion to dismiss pursuant to the Texas Citizens Participation Act. So let's go through this. This 16 pages. At least Sam is a concise drafter. Defendant Jamie Markey files this reply to plaintiff's response to defendant's TCPA motions to dismiss, and in support of this reply respectfully shows summary. This is good. This is good drafting, by the way. I've never grabbed her hair and pulled down. So, attachment to plaintiff's response, blah, blah. Ms. Markey certainly wouldn't be the first woman whose hair you've pulled. No, we've established that. Oh, and then they left that off? Wait a minute here. Do I have to... Hold on. That... Let's see. Oh my goodness. They left out the context. That seems pretty important. Do you guys see it? No, we've established that. ... But I would take issue with the word pulling hair. I mean, that seems pretty important. That seems pretty important. Sounds like something you do in a fight with somebody, and that is not the intent ever, nor do I believe they took it that way at the time. And then he also, in his affidavit, stated, you know, of course, which they're talking about here in the affidavit, that I've never grabbed her hair and pulled down. Because he didn't. According to him, he didn't do that. And he doesn't actually state it in the thing here. So is it possible that Miss Markey perceived pain when you pulled her hair in the lobby that day and that you were unaware of that? I had no indication when it happened that there was anything offensive or painful about it. That does not say yes, just so we know. Plaintiff's response premised entirely on conjecture and sham affidavits in lieu of facts. Bold to call them sham affidavits. What makes them shams, Sam? This fly, land so I can end your life. Oh my God. In lieu of facts, law, or rational argument, falls far short of establishing its absurd and often farcical assertions. Here's the thing, buddy. Here's the problem you face, Sam, is all evidentiary issues have to be resolved in favor of Vic at the TCPA stage. They do. They do. Hold on. Ah! I hit him again! Whereas Jamie's motion sets forth legal and factual bases for application of the TCPA and plaintiff's evidentiary shortcomings, plaintiff, on the other hand, chose to put before this court tabloid storytelling. Oh, that's rich. Whoa, that is rich, Sam, coming from your client. Coming from your client. Illegitimate argument. We don't know the father of the argument, I guess, and either no evidence or inadmissible evidence in a manner that begs the question whether plaintiff even cares to prevail against Jamie's motion in the first place. This reply is Jamie's effort to clean up the issues, if any even remain, in order for the court to find that dismissal under the TCPA is the only outcome allowed pursuant to Texas law. So, a very bold opening statement, but that's what I like about him, right? Plaintiff does not dispute that Jamie's tweets are communications as defined in the TCPA. Well, of course not. The only issues for the court to resolve then is whether such communications are based on, related to, or in response to Jamie's exercise of a right to free speech or right of association. They are. I think most people agree with this. The TCPA clarifies that the right of free speech is a communication made in connection with a matter of public concern. This isn't the winningest argument for you, though, Sam. Because following this, I'm guessing he's going to argue truth based on this. And he doesn't get to argue truth. That's not an affirmative defense he gets to raise on a matter of public concern, at least in Fort Worth, according to Kahn versus Vanderlinden. Okay. TCPA, yeah. A matter of public concern, in turn, is broadly defined as any issue related to health or safety, community well-being, and or public figure. Plaintiff simply fails in his attempt to limit the scope of the TCPA, plainly intended by the Texas legislature. Plaintiff failed to refute his general purpose public figure status. You haven't made the case for general purpose public figure status at all. Though plaintiff's treatment of Jamie's public figure argument is limited in his response, plaintiff's amended petition sufficiently sets up plaintiff's public figure status on its own. Now, I think they're citing the first amended petition. Despite filing this after the second amended petition was filed, I believe. Well, we can find out. Yep. When was the second amended petition? Hold on. What's okay, hold on. Oh, where is it? Response to motion to dismiss. Second amended petition. It's filed. Oh, I don't have the filing time on this one. Come on. I'm just going to open it here. Oh my gosh, go faster. I guess it is like a 500-page document, isn't it? Open. Oh, there it is. Filed, yeah, second amended petition was filed 9/3 at 12 a.m. So their response was filed, when was this? 4:16 p.m. So they could have addressed it. They chose not to. Using the first amended petition. But there you go. So that, okay. All right. I guess. Read the footnote. Yeah, the footnote just says plaintiff's amended petition. Set up a public figure status on his own. Vic is a voice actor who has performed voices of animated characters for over 22 years. Not a public figure argument. In 2018, Vic was cast the English voice for Broly, lead character in the fantasy martial arts anime film Dragon Ball Super Broly. Again, not a general purpose public figure argument at all. Was an instant financial success. Doesn't make him a public figure. In addition to his voice work, Vic attends fan conventions 35 to 40 per year. This is not a general purpose public figure. General purpose public figures are household names. Household names. Most people, most fans, at least prior to the lawsuit, didn't know who voiced Broly. Like that's the reality. Most fans who watch Dragon Ball could not have told you, especially prior to the lawsuit, who voiced Broly. They couldn't do it. Including me. Couldn't have told you. He earns a sizable income from signing autographs, taking photos with fans, and appearing on guest panels. That's, again, that doesn't actually establish general purpose public figure. Not at all. In Hirsch v. Tatum, the Texas Supreme Court, but this doesn't matter, right? This doesn't matter because this is just establishing that the TCPA applies. They then have to go to the actual malice thing, which they don't get to contest the truth of the statement or the falsity of the statement. So, and it's very likely that Jamie's statements would fall under the same exception that Vanderlinden versus Khan does. And of course, they'll argue that because the only people who can know exactly what happened are Jamie and Vic. Whether he whispered something sexual into her ear, whether he grabbed her hair and pulled it, whether he pulled her head close to his chest or whatever it is, all of that, those are false statements because Vic says they're false. At TCPA, that's how it goes. Unless you can show that someone else knew. And we've been asking for a witness the entire time. Nobody. No witnesses, never told anybody, nothing. So it's Jamie versus Vic, and Vic wins on that argument and shows actual malice according to Vanderlinden versus Khan. Something that Law Twitter has overlooked every single time. Hirsch v. Tatum's Texas Supreme Court held that when it's clear from plaintiff's pleadings that the action is covered by the TCPA, the defendant need show no more. Great. Need show no more. So you don't have to file any other evidence. And your other evidence is frivolous if you file anything else. The Hirsch court, which partially overturned the decision in Pickens v. Cordia, on which plaintiff relies in his response, relied solely on the plaintiff's petition in that case to determine that the TCPA applied. Without repeating the same herein, Jamie refers the court to her summary of plaintiff's relevant deposition testimony on pages 9 to 10 of her motion, together with the citations here too. Perhaps most importantly, plaintiff cites to almost no evidence to refute his status as a general purpose public figure. His generic argument and miscellaneous reference without supporting evidence as to IMDb credits of other celebrities in his response is underwhelming at best. The most obvious explanation is that plaintiff is unable to refute it. One sentence from plaintiff's deposition can hardly outweigh the deluge of data and evidence showing just how ubiquitous he is, especially but not only within the anime universe. Hey, wait a minute. That's an improper characterization of what a general purpose public figure is. They have to be so well known as to be pervasively known throughout they're pervasively known throughout basically American households and through the public at large. It's a general purpose public figure. That's it. So they're incorrectly stating the law, and of course they get to argue this at the motion hearing, so we'll see. Plaintiff failed to refute his limited purpose public figure status. Plaintiff inexplicably claims that there is no evidence in the court's record to establish that he is at a minimum a limited purpose public figure. Without admitting to the admissibility thereof, plaintiff's own evidence attached to his response clarifies that his transgressions have been public for years upon years, and that people, including those discussing it and those other than the immediate participants, are likely to feel the impact of its resolution. See generally the affidavit of Chuck Huber attached to plaintiff's response. Huber's affidavit doesn't actually say that it was generally known. He mentions a few specific people. But that plaintiff would dispute the fact that he has more than a trivial or tangential role in this matter, and that the alleged defamation by Jamie is germane to plaintiff's participation in the controversy is beyond belief. What participation has he had? They haven't actually shown any participation by Vic outside of, I think, 2 tweets. Something like that. Plaintiff doesn't comprehend notions of safety, welfare, or community well-being. TCPA is quite direct in its goal, however aspirational, of protecting the general public from the likes of plaintiff. Rather than addressing in any rational manner the clear and specific case made for why Jamie's statements relate to health, safety, and community well-being, plaintiff chose instead to shame Jamie for her silence. A silence brought about from plaintiff's reputation, power in their industry, and the weight of carrying what plaintiff did to her and others. Plaintiff's... Okay, so we read this. I'm going to read it again. Neither the TCPA nor Texas jurisprudence place a temporal limit on the well-established maxim that when a statement concerns even just an individual's state of safety, the TCPA applies. The only inquiry for this court is whether Jamie's statements relate to a matter of public concern, including health, safety, and community well-being. Plaintiff has not in good faith addressed Jamie's argument and evidence on this point, and in so failing, ceded it to her. Plaintiff's assertion that he's no George Clooney or Tom Hanks is certainly true on various different levels that exceed the appropriate scope of this reply. That's a dickish line. Plaintiff is rather more akin to Harvey Weinstein and Jeffrey Epstein. This is overplaying his hand. I mean, that is flatly prejudicial to the plaintiff. That is defamatory in itself. Hiding it in a pleading, of course. But it's defamatory in and of itself. Who were undoubtedly already public figures in their own right. Maybe. But even so, Harvey Weinstein and Jeffrey Epstein are much more prominent than Vic Mignogna. Much more prominent. But whose notoriety took on a vastly different appearance once their victims felt able to speak out about what happened to them. You're talking about a billionaire who is very much in the public eye, and Harvey Weinstein being the owner of a Hollywood production studio who attends all sorts of red carpet events that are televised, and is a known name, not only in the industry, but I think, wasn't it the Weinstein Company? Like, right? Why his name's on the production company of major motion pictures. Plaintiff's status as a public figure is undeniable, and his attempts to now minimize the impact of his career and widely known fame are disingenuous at best. Who widely knew about this? Perhaps even more so in light of plaintiff's own evidence showing the length and extent of accusations against him. Jamie's statements, and those of all his victims, are of the particular type the TCPA was intended to protect in the interest of health, safety, and community well-being. Plaintiff's legal action is also based on, relates to, or is in response to Jamie's exercise of her right of association. Plaintiff again has trouble articulating the precise nature of his dispute with the fact of Jamie's exercising her constitutional right of association. Plaintiff correctly states that the common interests required in the TCPA's definition of the right of association must be shared by the public at large, or at least a, they strike out definable, group. Strike through added. Okay. Following considerable lexicographical study, the court in Cowcack did not see fit to apply the TCPA where the right of association was conceded by the defendant to apply only to himself and his alleged co-conspirator. The word definable is not in the Cowcack decision opinion as implied by the plaintiff. Let's see. We conclude that the common interests required in the TCPA's definition of the right of association must be shared by the public or at least a group. We're not required to determine what group crosses the boundary of common. There you go. So they must have included the word definable, which seems very weird, but maybe they did. I don't know. Plaintiff's response, page 22. Oh, this is in the response to motion to dismiss. Let's check it out. Page 22. Okay. Let's see. Communication between individuals who join together to collectively express, promote, pursue, or defend common interests. Sort of expressive activities that are the essence of self-government. Oh, that's a little disingenuous. Common interest required in the TCPA's definition of the right of association must be shared by the public at large or at least a definable group. That's not a quote. Whoops. Okay. Sorry, I misread that. I thought they were trying to say that they quoted it incorrectly. No, they're making the argument that it's a definable group. So he's arguing against it. Okay, so it's probably not disingenuous. It's just two different arguments. Sorry. I had to clear that up. That was bothering me. Here, however, the online statements from Jamie and various other plaintiffs' victims certainly exceed the Cow Act court's holding that the two alleged co-conspirators alone didn't trigger the TCPA. Rather, Jamie and plaintiffs' other victims were exercising their right to express and pursue common interests among all women, including but not limited to plaintiffs' victims, and especially those who work or participate in the anime industry or its fan universe and associated events. The evidence attached to Jamie's motion established the necessity of their association and the importance of Jamie joining the community in solidarity and valor for all their sakes. For all of their sakes. They're all in danger. And for the sakes of those who may come after them. Yes. Yes. And he means literally come after them in time, not chase them down. So, Jamie met her burden in her motion to establish by a preponderance of the evidence that TCPA applies to plaintiff's claims in the lawsuit. Plaintiff failed to adequately refute application of the TCPA and now carries a burden to put forth clear and specific evidence of his claims against Jamie. Oh, yeah, get rid of that. Okay. So, plaintiff wholly failed to meet his evidentiary burden. As an initial matter, he doesn't have an evidentiary burden. He has a prima facie showing, which is not an evidentiary standard at all. Clear and specific evidence merely requires evidence that is clear and specific. It's not an evidentiary burden, so to speak. As an initial matter, because like evidentiary burdens are preponderance of the evidence, clear and convincing, or beyond a reasonable doubt. As an initial matter, Jamie points the court to the fact that plaintiff did not attach to his response. What is this? Hold on. Sorry, very important text message came in. I had to respond to it. Okay. Plaintiff did not attach to his response any admissible evidence setting forth a single statement alleged to have been made or published by her that is correspondingly alleged in his amended petition. In plaintiff's amended petition, plaintiff complains of 3 alleged Twitter statements by Jamie, only 2 of which are included in plaintiff's petition. However, plaintiff did not attach any of the statements to his response, let alone in admissible format. Plaintiff thus wholly failed to proffer any evidence at all of any defamatory statement by Jamie. Even ignoring their lack of credibility and apparent improper notarization, the inadmissible evidence in plaintiff's sham affidavits does not support a single allegation in plaintiff's amended petition as to Jamie. Plaintiff has hardly even attempted to meet his significant burden to set forth by clear and specific evidence a prima facie case for each element of his claims against Jamie. So in this second amended petition, oh man. Well, it's attached in here, right? Where did it go? Let's search for balls. Weird. Here it is. In the second amended petition, it's attached. I wonder if we can find it in here. Take a little bit longer to search through 1,100 pages. Searching. Oh, look. Exhibit attached here too. Jamie's "I want his balls" quote. So it actually is in here somewhere. Apparently. I'm not sure where. I'm not going to search through it. But it is attached in the Second Amendment petition pretty clearly. I want his head, I want his balls. What's the other one? Jamie's, it happened to me. Well. Here we go. It's right here. Here it is in the Second Amended petition as well. Uh-oh. Wait a minute. Does Jamie Markey right here? He's saying I'm lying and I know that I'm telling the truth, which means he's lying. So I am in fact justified in saying he's lying and people shouldn't believe him. Hey Ty, if you happen to see this, Ty, she just made the argument that her knowing the truth means that he's lying. I think we should hold her to that standard, right? That's what we should do. We should hold her to that same exact standard. If Vic is telling the truth, then Jamie must be lying and know about it. So there you go. And people shouldn't believe her too. That's interesting. That sounds like knowledge of the falsity, right? She just articulated knowledge of the falsity right there. I wonder if that's why they included this response. Because notice it's highlighted. I have to wager. Here we go. So, they do definitely include it here. I believe they've included it in other filings. He says not in admissible format. Sure, Pumpkin. We'll have to see, I suppose. We'll have to see. The interesting thing is, of course, merely alleging it in the pleadings is evidence. According to the TCPA, the pleadings are evidence. So, I guess we'll have to see how Chup rules on that. So here we go. Even ignoring their lack of credibility and apparent improper notarization, the inadmissible evidence in plaintiff's sham affidavits does not support a single allegation in plaintiff's amended petition as to Jamie. Plaintiff has hardly even attempted to meet his significant burden to set forth by clear and specific evidence a prima facie case for each element of his claims against Jamie. Yeah, run with that argument, man. We'll see how it goes. Last, Vandalier says, will Funimation lose the license to Dragon Ball with all this horrible publicity, seeing as Goku is going to be one of the ambassadors for the Olympics 2020 in Japan? I don't know if they will or not. But I know that they've got to be doing damage control right now. Their damage control is pretty apparent. They're not making public statements about it. Has Funimation had a history of not making public statements, or did they make public statements when there was a public outcry? They sure did, didn't they? I think maybe they don't feel so confident about this one and are working behind the scenes. To figure that out. Plaintiff failed to proffer clear and specific evidence for his defamation claim against Jamie. Plaintiff dedicates essentially one 9-word sentence and one 7-word sentence, 3 of which were Vic, Monica, and Ron, of his response to Jamie in regard to allegedly defamatory statements by her. Plaintiff cited no evidence and did not bother to delineate between each defendant when briefing his generalizations. A plaintiff claiming defamation must show that the defendant published a statement of fact. Plaintiff did not submit any evidence at all that Jamie published a statement of fact. I mean, it's in deposition as well. In the deposition, he talks about the case, and I believe, doesn't he? I don't know if he does in the deposition. We'll have to see. Actually, we won't have to see. We'll have to see how the argument goes, because I'm not looking through that. Plaintiff claiming defamation must show that the defendant published a statement referring to the plaintiff. Plaintiff did not submit any evidence at all. Jamie published a statement referring to the plaintiff. Plaintiff's evidence does show that nearly all of the tweets of plaintiff apparently complains don't even reference plaintiff. You know, of course, the interesting thing is they should be able to bring any of this evidence to the hearing as well. Plaintiff claiming defamation must show that the defendant published a defamatory statement. Plaintiff did not submit any evidence. And here's the catch-22 that they're in. If this is not an evidentiary hearing, then the second amended petition applies. Okay? Because if it's not an evidentiary hearing, it's not a trial. Period. So if it's not an evidentiary hearing and they can't introduce evidence at the hearing, the second amended petition applies. If they argue that it is an evidentiary hearing and is a trial, and the second amended petition needs to be thrown out for being not timely, it's an argument they can make, but if they make that argument, then it's a trial, which means it's an evidentiary hearing, which means they could bring the evidence to the hearing. So there you go. They're gonna have troubles with this. Plaintiff claiming defamation must show that the defendant published a statement referring to the plaintiff. Plaintiff did not submit any evidence at all. Jamie published a statement referring to the plaintiff. Plaintiff's evidence does show that nearly all of the tweets of which plaintiff apparently complains don't even reference plaintiff. A plaintiff claiming defamation must show that the defendant published a defamatory statement. No evidence that she published a defamatory statement. Plaintiff claiming defamation must show the defendant published a false statement. Does not submit any credible or admissible evidence at all that Jamie published a false statement. Assuming without admitting that plaintiff's sham affidavit has any veracity, it directly contradicts plaintiff's deposition testimony. I've never grabbed her hair and pulled it down. Deposition testimony, and I was kind of standing there, kind of flipping it, like, oh my gosh, it's really beautiful, I love it, and I put my hand up in the bottom of it, and like, oh, this is great. Stated while recreating how he grabbed and pulled Jamie's hair down. That's not what he said, Sam. That's not what he said. That's disingenuous. Very disingenuous. Plaintiff's deposition testimony. I had no indication of that when it happened. When asked if Jamie could have perceived pain. No, we've established that. When asked if Jamie is the first woman whose hair he pulled. And the established was... see, this is disingenuous too. I would hammer on these. Because that's pretty scummy to take the words out of their clear context. Which again, all of these issues must be resolved in favor of Vic. If they're not... they're all appealable. They're all appealable. They have to be resolved in favor of Vic because that's how it works. Plaintiff claiming defamation must show the defendant published a statement with actual malice or alternatively negligently. Plaintiff did not submit any evidence at all that Jamie acted with malice. He certainly assumes it and claims it, but did not establish it as he is required to. Actual malice in the context of defamation claims refers not to bad motive or ill will, but to knowledge of, reckless disregard for, and falsity of the statement. Well, right there. 5th of March. She just said it. She just established it right there. So, good luck. Other than his admission to the truth of Jamie's primary statement, which is omitted from plaintiff's evidence, because he didn't actually admit to it. You're lying about that. Plaintiff neither filed nor cited to any evidence of actual malice on Jamie's part. Instead, plaintiff's testimony confirms that even though plaintiff may not have considered his abrupt, uninvited jerking of Jamie's head and neck offensive or painful, Jamie very well could have. In fact, plaintiff agrees that the way one person perceives a situation is not always going to be the same way another person may perceive the same situation. That's about opinion, though. That's not about statements of fact. He's muddying the waters on this argument here. Plaintiff claiming defamation must show the defendant's statement caused the plaintiff pecuniary injury. They're per se defamatory because she's accusing him of sexual misconduct, right? Where is it? That's the head and balls quote. Pain he's caused on another and then effing choke on it. I want you to take his dick out of your ears so that you can actually hear reality, but you know that's just me. Even for an affectionate environment, this felt off. I didn't say anything to him about it, though. It's just his fingers in my hair. I didn't think it was a big deal at that point. When he did this, he grabbed my hair close to the root, whispered something in my ear. Don't remember what he said specifically, but I do remember it being sexual in nature, not normal, not a hug or kiss on the cheek. I did not like it. She's accusing him of sexual misconduct, which is per se defamatory. So he doesn't actually have to show any damages. Because they're presumed. Please address the Sabbath denial statement on Twitter. What Sabbath denial statement? I don't see a Sabbath denial statement on Twitter. So, Oh, yeah. I don't really care about that right now. Yep, I don't know. I don't see a denial by Sabbath on Twitter. So did he delete it like all of the other things he said lately? So let's see. Yeah, it's also simple assault. Thanks, Awig. It's also simple assault, so it's per se defamatory in that way. But show causation nor provable damage nor a reliable basis for calculating same, which he doesn't have to do at this point in time. He just has to make a prima facie showing that the statement is per se defamatory. Damages are presumed, and they don't have to. They can be nominal damages as well. It's in the ANN article. Oh, okay, I'm gonna go to the ANN article in just a minute. Plaintiff failed to proffer clear and specific evidence for his claim against Jamie for TI with existing contracts. Plaintiff generically conflates his claims for TI with existing contracts and TI with prospective relations. Even worse than his defamation claims, plaintiff's briefing does not even attempt to identify specific defendant or the specific contract they allegedly interfered with, nor does plaintiff proffer a cite to a single contract interfered with. Instead, Jamie and court are again left to guess what plaintiff thinks may support his claims. That's not true. He's actually alleged several specific contracts. Even in his first petition. Plaintiff claiming TI must show that the plaintiff had a valid contract. Actually being announced, making the claim, the pleadings are evidence, and those pleadings saying I had a contract to appear at, or I had an agreement to appear at, or I was announced at, are clear and specific evidence of a contract with a convention. They just are. They are. And to argue otherwise is silly. I mean, you have to do it, right? But that is a clear and specific evidence of a contract. I was announced to appear at a con for money. Period. That is a contract. There it is. You've got one. Texas recognizes oral contracts. You don't have to produce a paper contract. Even just the allegation in the pleading is clear and specific evidence of it. That's it. He listed the specific contracts. You could say that any contracts that weren't listed aren't specific. Okay, go for it. Go for it. And interestingly, if you're going to say that he didn't have a specific contract with any one of those conventions, fine. Say that. Okay, but he was announced, so now it's clear and specific evidence of TI with prospective business relations. Because the contract was going to occur, maybe it just wasn't executed yet. That's the argument in the alternative. I would argue that the moment you're announced for a convention and you have some sort of agreement, and the reason I would argue this is because it's true, then you have a contract that is valid and executable in Texas. That agreement says you're going to appear on this date at this convention for this much money. Contract. Done. Clear and specific evidence. They're trying to make this very complicated. It's really not. A plaintiff claiming TI with existing contracts must show the plaintiff had a valid contract. TI with existing contracts. Defendant willfully and intentionally interfered with that contract. This is a little tougher on Markey. But the part of it goes to the civil conspiracy claim. All right. Plaintiff's evidence only establishes his lack of evidence. Specifically, that plaintiff doesn't know any of any conventions Jamie allegedly contacted. Plaintiff claiming TI must show that the defendant's interference proximately caused the plaintiff's alleged injury. TI with existing contracts must show that the plaintiff incurred actual damages or loss. He did, actually, in his sham affidavit, does not include a cursory, non-specific discussion detailing his pay for attending conventions this year. Only $161,000 so far. Or does include. And then assuming that he would have made certain amounts at certain conventions that allegedly canceled his appearance, but nowhere did plaintiff offer up any evidence to show provable damages or reliable basis for calculating the same. They only rounded down in the appearances he did have and then assumed the smallest number. So, I mean, you know, there you go. Plaintiff failed, and that's a prima facie showing. I can't. It's a prima facie showing. Plaintiff failed to proffer clear and specific evidence, TI with prospective relations. This is the same stuff, right? And again, this is getting annoying, and I'm getting kind of tired of going through these documents because now we just have to see at the hearing. We just have to see at the hearing. Figget Tree says, how dare you? Jamie Markey is innocent and totally not fat. Being 300 pounds at 5'3" is normal, and Sabat is a good boy who didn't do nothing. Who cares that he traded roles for sex? Vic is gay and attracted to women. No, Markey was not at Kamehacon. Boy do Nguyen. When? So yeah, he's going to just keep saying, plaintiff nobly gave the new meaning of the phrase conspiracy theory in his response. Theories are, after all, the only foundation, however faulty, on which plaintiff can claim for civil conspiracy stands. Interestingly, Jamie is mentioned in plaintiff's conspiracy theory section of the response more than any other section. Even the most creative writing and logical fallacies cannot jump the significant gaps that remain persistent in this claim asserted by plaintiff. Plaintiff cites yet again to no supporting evidence. We'll see if he brings it to the hearing. Incorporation by reference to the extent applicable to plaintiff's claims against Jamie. Jamie incorporates defendant's Funimation Real and Toei's arguments, authorities, and evidence. Conclusion. I mean, Chuck Huber's affidavit pretty much makes the case for conspiracy, at least parts of it. So, but we'll have to see. We'll have to see. I've always said that Markey's got the strongest claim. When Jamie spoke out about what plaintiff had done to her, she did so with the clear intent to protect herself and support victims of assault throughout the community, having shown in her motion that her constitutional rights of free speech and association are implicated by plaintiff's claims, except she doesn't have a constitutional right to lie about what Vic did. Jamie successfully shifted the burden of proof to plaintiff, yet even with ample time and extension, plaintiff failed to meet his evidentiary burden by a long shot. Against reason and understanding, plaintiff chose instead to focus on tabloid allegations and inconceivable arguments rather than provide the court with admissible evidence for each of his claims. Plaintiff contradicted his own deposition testimony, speculated and generalized, and wholly failed to even attempt in good faith to meet his burden. Extending his lack of credibility, plaintiff attached fraudulently notarized affidavits as his primary support, without any specific showing where Jamie said or did anything attributable to his alleged damages. Plaintiff cannot be permitted to continue with this most dubious of lawsuits. Especially in light of plaintiff's contradictory testimony, Jamie's motion to dismiss must be granted. Her evidence is strong and her arguments solid. Everyday women, notice what he doesn't do here is he doesn't make affirmative defenses. Everyday women speak out about what their aggressors have done to them, and the TCPA is intended to protect these brave victims by protecting their constitutional rights. Reviewing Jamie's motion, plaintiff's response, and the court record, dismissal is the only outcome consistent with Texas law, even more so when the safety and welfare of so many lie in the balance. So this is interesting because if Vic meets his burden, then they do not argue any affirmative defenses. I think they should have tried. I don't know what affirmative defense they would pick, but they should have tried. Because if Vic happens to meet his burden, then they lose the TCPA for that cause of action. I think Vic will meet his burden, but we'll see. We'll see. Like I said, admittedly, Markey's got the weakest claim, or the strongest claim. Vic's got the weakest claim against Markey. But that's something I've said for a long time. But we'll see. We'll see. So there's that. Let's get that ANN article. Hold up. What was that? Fix your camera. My camera's fine. Boy, you knew yen would be approximate way to say. Okay, thanks. I'll try and remember that. Let's see. Just emailed you some clips found on Twitter. I think these are good to show. I'll have to review them. I don't like jumping into video clips mid-show, ever. Oh, I didn't have live chat on. Dang it. Okay. So, here we go. Okay, where are we? So here's the ANN article. I haven't read this yet, but let's go through it. ANN, hey, it's great. I don't know if you guys, have you heard of ANN, Anime News Network? The most trusted name in anime, right? Tucker says, dude, Jamie not going to sleep with you. I know she's promised that in lieu of fees. Whoa! But it's not going to happen. You can lay off with the cuckery. I don't know if you guys are familiar with ANN, the most trusted name in anime. But when the Dragon Ball leaks dropped and the rest of the world was talking about them, including Yahoo Japan, voice actors in Japan and the United States, Dragon Ball voice actors in the United States, everybody's talking about them. ANN, what are you talking about? What do you guys even, what do you mean? What are you talking about? Nothing. Not a word. Not a word. But some filings in Vic's case, man, they got it. They got it. They're on it. Okay. So we'll read the updates in a minute. The Labor Day, they're running. This is disgusting. I just read the first, I skimmed the update just a bit and caught some words, and I'm already pissed off. So here we go. The Labor Day weekend filings for voice actor Vic Mignogna's ongoing civil court case against his former colleagues Monica Rial and Jamie Marchi, Rial's fiance Ronald Toya, and Funimation had more twists than a David Lynch film. Following July's earlier filings by the defense, Mignogna's legal counsel Ty Beard was on a deadline to file his response by August 30th. As previously agreed by both parties, Beard missed his deadline by a matter of minutes, but what was filed would feed into a new round of rumors and speculation about the talent working at Funimation, at least until Monday, when Beard followed up with a notice to withdraw all 3 notarized affidavits due to defects in form. And the court judge ruled against his motion to strike the defense's evidence. This is an improper statement, you morons. Just Funimation's. Just Funimation's evidence. I know none of you are lawyers, and it's not just that you're not lawyers, it's that you're also disabled in the nicest sense. But he only moved to strike. He only overruled the motions to strike Funimation's evidence submitted in the first motion. That's it. That's it. Automata says, so if people went ahead and created Olympic-themed Goku memes with the leaked funny audio, do you think that's something Japan would take notice of? Also, those responses kept referring to affidavits not in evidence. No? Yep, they did. They kept referring to affidavits not in evidence. And they didn't address the second amended petition, which was filed prior to their filings by, what? 16 hours. And was served on all the parties probably prior to that. But that's something to remember, right? Sam Johnson ignored the second amended petition, which was filed 16 hours prior to his filing. And his filing was filed near the end of business, near close of business that day, which is fine. There's nothing wrong with that. But even if he argues, well, I didn't get into the office until 10, he still had he still had over 6 hours to see the second amended petition, which would have been served on him and in the filings, and was being discussed actively and had been discussed via email prior to it. So, he doesn't make any argument as to why the second amended petition is not good enough. He doesn't even acknowledge its existence. That seems like a mistake to me, but I don't know. Okay. The defense has responded, calling for sanctions and alleging illegal conduct by Beard and co-counsel Jim Bullock under suspicion that the affidavits, which were notarized by Beard himself, were falsified. Is that the suspicion now? Because I don't think that was a suspicion. I think the suspicion was that the notaries were defective, and they were claiming that the notaries were fraudulent, which defective notary and fraudulent notary, two very different things. But now Anime News Network has manifested that the suspicion that the affidavits themselves were falsified. In the state of Texas, a notarized document has to be signed in the presence of his notary. The defense's counsel is calling into question whether Mignana Kamehacon owner Chris Slatosh and voice actor Chuck Huber actually appeared in front of Ty Beard on August 30th when the documents were notarized. Slatosh was allegedly attending the San Japan convention at the time, according to a photo with a timestamp on Instagram, located in San Antonio, approximately 5 hours away from Beard's office in Tyler. Additionally, Beard filed a motion for the court to accept the late filing, citing technical issues as the cause. Filing itself was 27 minutes past deadline. However, the attached notification of submission error shows that Beard's partner Jim Bullock did not attempt to upload the files to the court system until 12:15 a.m. on August 31st. This is not actually true either. That's not what it shows. Beard followed with a second amended petition on September 2nd that included the previous affidavits. However, they are no longer notarized like those included in the original filing. They're called unsworn declarations. I guess let's pull this up. Civil Practice and Remedies Code, Title 6, Chapter 132. Just for the people in the back. For the pretend journalists. Except as provided in subsection B, an unsworn declaration may be used in lieu of a written sworn declaration, verification, certification, oath, or affidavit required by statute or required by a rule, order, or requirement adopted as provided by law. Period. Unsworn declarations, which include the following jurat, made under the section must be in writing and subscribed by the person making the declaration as true under penalty of perjury. So there you go. And it is, except as provided by subsections E and F, an unsworn declaration made under this section must include a jurat in substantially the following form. My name is blah, blah, blah. Date of birth is blah, and my address is blah, blah, blah. And I declare under penalty of perjury, or under penalty of under penalty of perjury, that the foregoing is true and correct, executed here. So that's it. That has the same effect as an affidavit. It's done. So pretending that these unsworn declarations are somehow less or different than an affidavit is silly, because the affiants in the affidavits that are defective as to form have signed under penalty of perjury unsworn declarations. Everybody's making a big deal out of this. It's in the rule. It's in the rules that this works. The exception is this section does not apply to a lien required to be filed with the county clerk, an instrument concerning real or personal property required to be filed with the county clerk, or an oath of office or an oath required to be taken before a specified official other than a notary public. It's in the rule. Unsworn declarations are just fine. So again, even if you complain about the notary and you say that the notary is a problem, the notarization isn't required. An unsworn declaration suffices. So even if they screwed up the notary, and we don't actually know that's what happened yet, but even if they screwed up the notary, they can replace it with an unsworn declaration, and every single one of these attorneys knows it. Why do you think they're so scared of them? But just to be clear, I don't think Law Twitter is covering that for some reason. God, oh, jeez. I don't know why. Why they're not covering that. Yes, I know about remote notarization. But until someone makes an argument for remote notarization that's relevant to the case, I'm not going to put that out there. Because I don't know what happened. Okay? What I do know is that if they found the form defective on the notaries, then they pulled them down. No one was impacted by them. There's no harm to the court. And they produced identical unsworn declarations made under penalty of perjury by the exact same people who signed the notary. It's going to be pretty flipping hard to show some intent to defraud the court. It's going to be pretty flipping hard to show any intent to do anything malicious at all. Because the people who signed the affidavits have also signed under penalty of perjury substantially identical documents. What are you going to say? That they didn't sign the other ones? Is that going to be your argument? I mean, that's what ANN is saying. That's what T. Greg, I think, said. I guess prove it. Dark Foxen says, defense strategy, make a claim. 2, air dirty laundry. 3, defend our case. Why? 4, spin cycle plaintiff statements. 5, push that narrative. 6, refer to Law Twitter. Yep. Okay, anyway, back to it. Both of the plaintiff's petitions allege that Funimation Productions was amorous and sexually charged for years, and cited panty and stocking with garter belt and anime starring both Rial and Markey, and prison school as examples of the company's products. It's unclear what, if any, bearing a sexually charged atmosphere at Funimation would play into the validity of the mountain of accusations levied against Manana. Oh, it's unclear because you're stupid. But multiple former Funimation staff members that spoke with Anime News Network denied the characterization set forth in the amended petition. Oh, good. Good. If only they put out their affidavits, right? Chuck Huber's affidavit included these accusations about the Funimation work environment and made multiple startling accusations involving Dragon Ball Z voice actor and Okratron 5000 dubbing studio owner Christopher Sabat. Huber alleged that Sabat, who is not a defendant in the lawsuit, spoke poorly of Mignogna, referred to him as a pedophile as far back as 2003 or 2004. By the way, I'm not going to finish reading this article, just so we're clear. Because Anime News Network is prone to making false DMCA strikes, and we're going to avoid that. And criticize Mignogna for his acts of infidelity, Christian beliefs, political opinions, and behavior at work. Huber also alleged that failure to maintain a positive relationship with Sabat could lead to fewer roles for a voice actor, and that employees treated Sabat as a de facto manager. But let's read. Sabat provided Anime News Network with the following statement regarding Huber's allegations. So after I read this, we're going to go ahead and move on. The recent allegations of sexual misconduct at Funimation Okratron 5000 are deeply disturbing and completely without merit. Are they, Sabat? Are they, Sabat? You better hope. You better hope that they're completely without merit, because a lot of people are talking about them. These libelous statements are based on groundless rumors and are meant to defame me and my company. Never in my career spanning 2 decades did I ever witness or participate in such conduct. Oh, Chris. Are you sure, Chris? Are you sure? I guess we'll see. We got to wait and find out from people like Stephanie. Stephanie, anybody else, please, you've got to come forward. You should do it now. You should do it now. Now's the time. Okay, let's read this. So here's the update that they provided. After the update, we're going to be done with this article. This is obviously, here's my criticism. This is clearly a hit piece. It's a fluff piece for Sabat. They've got Sabat's balls right in their mouth, which is pretty freaking obvious from taking that statement and how they're writing everything. Oh, it's startling. These guys, Remember, Anime News Network is pretending to be the internet's most trusted anime news source. They have insider contacts at all of this, and they're suddenly going to write an article pretending Funimation isn't a sexually charged workplace. Despite, where is it? Where is it? Never mind. We're going back. We're going back to this document right here. No, not this one. Not this one. This one. Let's. What does Jamie Markey say? Now, I do work in an affectionate industry. We hug a lot, and on occasion, we'll give a kiss on the cheek. It's not sexually charged? No, I never have. Sony had to implement a no hugging policy because it wasn't sexually charged, right? Right? Come on now. Come on now. So update 9/4/19 in an audio interview with Jason of Maven Collectibles published in February 2019, Stephanie Nadolny said that in approximately December 2010, a female friend told her that she was being replaced in the Dragon Ball franchise. Nadolny states that she does not know why she was replaced. The director made a decision to make some changes and there's nothing I can do about it, Nadolny said. She stated that her last audition was with voice actor Mike McFarland in 2009, and it was the last time she heard from anyone at Funimation. I'm still very hurt by it, Nadolny said. I was blindsided. No one explained anything to me. Nadolny goes on to say that she suspected her dismissal might have been in part due to a breakup with a man she was dating from 2003 to 2009. When we split, he absolutely completely freaked out and his ego was affected like, I'm going to ruin your career. He called all my employers and aired my business, Nadolny said. I think that's what kind of led to me not being able to reprise my character. Nadolny described the situation as pushing her out of the clique within Funimation. She described the fallout from the breakup as abusive and threatening. In the interview, Nadolny stated she had at least 3 witnesses to her ex's behavior, as well as email evidence. Who is the ex? Come on, Anime News Network! Oh, I broke the mic. Did I kill the mic? I'm like killing it. You know, who is she dating? Who is she dating? Just answer the question. You already know the answer, Anime News Network. Who was she dating? You already know. Such bad liars. Oh! At least say who it is, you lying, disingenuous piles of garbage. These people, Anime News Network, lying, lying by omission right there in front of us. Who was she dating? Who was it? Let's see. Hold on. Let's see. Hold on, I'm looking for something for you guys. Sorry. I'd love to just have this right at my fingertips. I have it close. Just pull this up real quick. I just want to verify something. Okay. Here we go. There it is. Mm-hmm. Oh, it doesn't say. Doesn't say. Okay. Well, I won't say it then. I won't say it then. And this is a travesty of anything even close to journalism. Anyway, I think you guys can figure it out. Who is she dating? 2003 to 2009. That's it. That's it. I can't go on this. How disingenuous these people are. Okay. I'm not going to say it. I think you guys know. I think it's been said a whole bunch. All right. Let's see. What we're going to do. Oh, I want to do one final thing, and this is a personal thing before we go to super chats. So don't leave just yet. Got one personal favor to request here from people. I don't like to request favors so often, but I wanted to show you guys something. Come on, where is it? Here we go. So I'm going to show this. I'm going to do this one more time on stream here. So this is I showed this before. This is my friend, personal friend of mine, who is trying to have a classroom library. He's a school teacher, and he's trying to acquire 1,000 to 2,500 books because research has suggested that many books is, I guess, the threshold amount for a diverse group of students to be able to satisfy a diverse set of interests. Okay, so he's an English teacher. He wants to have this classroom library that is more robust than the school library and tailored towards his class's age. So that's the idea. I had him on the stream. He wasn't the best received guest, but regardless of that, his intentions are really good, and he's a really good guy. I think he came across in a way that is not technically accurate of who he is, and but that's okay, which is fine. That's how the internet goes, right? But he did raise $1,100, and I wanted to show you guys he did buy books, and he actually bought books that are he incorporated donor suggestions. So the donors are suggesting books, and he was doing that. I'm going to make a donation on air tonight to this to tell you guys that if I'm promoting something like this, I put my dollars where my heart is, right? And I believe in this cause. So I was going to ask you guys, because the school year is starting, and so he's going to be wrapping up this GoFundMe. So if this is something that you're interested in, I wanted to point out that he did buy something like with the $1,100, he's bought over 100 books to do that. Again, his idea is that about $10 a book is the kind of threshold target, including shipping and stuff like that. So I'm going to make a donation right now. I'll show you guys that donation in just a second. Oh, here we go. There we go. Oh, here we go. Doing this without doxing myself. Just a minute. Oh, come on. Do I need to... Just a moment. Technical difficulties. Let's do this. This is the best television right here. This was supposed to go much smoother, of course. But we've got go. Next. Did we get it? Did we get it? There we go. Skip that. Back to campaign. Oh, update it. Are you serious? I hate you, Gofundme. Okay, well, any minute now, it'll update. While we wait, let me address the fake Gofundme that was created today. We'll talk about that. This did not go the way I planned. I'm waiting for it to actually update with my donation. Come on. Come on. Okay, so while we do that, yes, a fake GoFundMe was created by someone apparently on the KickVic side today. This person has a history in the KickVic movement. And if you want to find out about that history, you can do that. I'm not suggesting anybody bother this kid. Seems like he made a very stupid decision. But the long and short is a false GoFundMe was created, and it was basically a copy and paste of mine, except that it also alleged that my Twitter and Facebook were hacked. And so not to pay attention to anything like that, I contacted my GoFundMe contact immediately, which, shocker, if you have a campaign that raises 6 figures, GoFundMe has a contact for you. Oh yeah, I'll put the link for the GoFundMe. 1 second. Here you go. Sorry. Good call. Good call. Here's the link. I spammed it. I've spammed it. Mods, if you can go ahead and throw that out there as well. And I'll add it to the description of the video in a little bit. Come on, show my donation. Okay, spoiler alert, because it's like not gonna show up. Can I show the donors? What about me? Where's mine? Okay, I donated $750. I'm trying to show that. Because again, I actually believe in this cause, and I know Heath to be a good guy, and I had planned on making a large donation from the start, but when he said that he's got to get more books because the school year is starting, I said, oh, I got to make it today. So, yeah. So I made a $750 donation eventually. Maybe if I try a different browser. Maybe we do that real quick. Again, I want you guys to know that I don't ask people personally to donate stuff unless I, believe in it. And I really do. Here we go. So Brave browser has the update. Chrome must just be using a cached version or something. But here. So there you go. You can see it. There's my donation. It's not I'm not like bragging or anything like that. It's just a cause I believe in. I do try to support several charities. This isn't a charity. Don't make that mistake. This is not a 501c3 donation, but it is somebody I believe in. and for a good cause. So if you guys feel compelled or called in any way to donate to that, I'd appreciate you helping him out. He's going to shut it down sometime soon, I believe as he picks up some more books and goes into the school year. But there you go, guys. Please check that out. And one more time, I'll spam it in chat. So there you go. All right. Let's go to the other GoFundMe because there's other news. Oh yeah, so GoFundMe reacted immediately. My contact reacted immediately when I sent the fraudulent GoFundMe in and said, hey, this person is using my name to create a false GoFundMe. Please correct it as soon as possible. And of course they did because, right, they don't like their platform being used for fraud. So here we are with Vic's GoFundMe, $242,446. And I have an announcement. I have been given permission by GoFundMe to do one part of the things I want to do. Okay? And that is, hold on. I have these 5 signed prints that were donated. They were donated anonymously. 5 signed prints donated to give out as thank yous. Let's see. Got this one. This one. These are the glossy prints you would get at a convention. I've got these 5 signed prints, and GoFundMe has given me permission to offer a thank you giveaway of these 5 prints. So what's going to happen is very soon I will announce this. I will announce this as soon as I figure out the exact date. So I may even announce it tomorrow, but I'm going to pick a date range. And there will be, I will pick the highest donors, the 5 highest donors in that date range. And at rant, I can't let you pick a print, unfortunately. But the 5 highest donors, cumulative donations for the date range in question, and I will I will get into contact with that person through the GoFundMe system, and they can, if they want a print, they will give me their mailing info and I will send them out as a thank you. The value of these is between 40 and 60 bucks. And that is GoFundMe has given me permission to do that. It doesn't matter how much you give. If the highest donation is $1 during that time period, they will get a print, right? Like that's the thing. It'll just be during that time period, the highest cumulative donations will go. The goal, of course, is to push up contributions to the GoFundMe and then to thank the people who are the highest contributors. And that is, that is perfectly all right. But I can't let you pick a print or anything like that. So that will be announced very, very, very soon. Like maybe even tomorrow. I just got to pick a date range. So stay tuned on Twitter and on YouTube for that announcement. And yeah, I'll probably just I'll announce it during whatever live stream, but I'll probably just make a video and announce it. Right? So it gets maximum exposure. But yeah, so keep your eyes peeled for that in the next day. Yeah, dox yourself for posters. I'm still waiting on the knives. Permission from GoFundMe on the knives. The third knife, I believe, is really close to done and should be arriving shortly. I've asked them permission, but they have to get permission to allow me to give away a knife. They're decorative knives, ornamental, but they have to make sure that they're allowed to do that through their system. And they have been great working with me on this. recently. I had trouble getting answers before, but it seemed like there was just a slip up in communication somewhere, and I don't fault them for that. They've been great working with me on this over the past couple days and getting me, answers. So I'm very appreciative of that. So, there you go. This will cut off donations until then. That's fine. I'm gonna announce it tomorrow, and it's gonna be right away. Like we're not talking about, oh, this is gonna be 3-4 weeks away. No, this is gonna be very quick. We've gotten permission. I've been waiting for permission to do this, and we've got it. So that's the update I have on the GoFundMe. So yes, if you are thinking of donating more than a very small amount, I would hold on to those dollary dues for the next 24 hours at least, until you see the announcement come forward. Anonymous donors, I don't have a way to tally up an anonymous donation. I can't do it. Oh wait, that may not be true. Let me check one thing. I might be able to do it for anonymous donors too. Give me a second. Hold on. I'm checking how this looks. There's an anonymous and there's 2 more anonymous here. Yeah, anonymous donations that are actually done anonymously, I can't see who it is, even on my donation window. So there are private donations that are different, I think. Maybe not. No. I might have. I'll try and get some clarity on how specifically to do this. Okay, actually, I do see names. When they show up on anonymous on the donations. I see the names in the thing here, in the campaign comments. So it looks like anonymous donations will work. So, but I'll double check that with GoFundMe and verify that. But it looks like anonymous donations will work as well. I just have, like I said, this is why I'm going to do a specific time period, because otherwise I'd be going back through all sorts of stuff. But yeah, so there you go. We'll be doing that. I obviously can't announce the anonymous people's names unless they give me permission to. There is a way to include anons. So your name will show up as anonymous on here, but I see the name that you put on the campaign donation. So, and you're gonna need to dox yourself to me, of course, for me to mail something to you. But that's different. But yeah, so there you go. The problem with, yeah, never mind. Ken says, we'll be finishing the handle on the last one tomorrow after I get my teeth extracted. Sheath done on Friday. Just got home, by the way. Hey, welcome, Ken. Welcome, Ken. And thanks for the update. Okay, so that's the GoFundMe update. So the posters tomorrow. Look for an announcement tomorrow. And yes, anons are covered because I see the name that you put in. Even when it's kept private from everybody else, I see the name. So I don't get other information. So again, I'll have to message people and work out the shipping, but we'll do it. We'll do it. All right. let's get out of here. All right, if you're tuning out now, thank you for hanging out. We're gonna do super chats. I will do some Twitch thoughterry tonight as well, but we're gonna do super chats. I don't know how long I'll go tonight because I've got an early day tomorrow, and then I've got a mysterious plane ride to take. So who knows? I'm like Carmen Sandiego, traveling all over the flipping country. So let's do that. But yeah, thank you for watching and hanging out. I'm not sure exactly what tomorrow's schedule looks like. I don't know if there will be a show or not, a live show or not tomorrow, but a video of some sort about the GoFundMe campaign will come out, even if it's just a cell phone video. That'll happen. But yeah, so we'll talk then. All right, guys. Thanks for hanging out with me tonight. If you're leaving, otherwise stay. There's always funny stuff in the super chats. Asia Frazier says, next time I super chat, I'll be 28. Hey, awesome. Awesome. Happy birthday. Sean Kerr says, lost our daughter and now our cat needs surgery. GoFundMe help with Castiel's bladder surgery. Oh my God. I'm sorry to hear that, man. Caleb Lambright says, you are blessed, Nick. Oh, thank you. Evan Rogers says, some cosplayer is claiming OG Gohan's Twitter was hacked. I can send you the screenshots. Bad Vibe says, stupid twits play stupid games, winning stupid prizes. I think these folk are grasping for any payday they can. Oh, I did forget to mention the guy who created the fake GoFundMe has apologized for it profusely. I've accepted the apology. Of course, you know, any legal ramifications, of which I doubt there will be any. But any legal ramifications are not up to me at all. My apology is he owned up to it. He apologized, and I'll accept that. I think it was a stupid mistake, but you know, there you go. B19 Rando says, so Nick, is the whole Vic thing the Chewbacca defense in action, or is Moron just stupid? Well, it's the second one. Kalinka Pavlova says, what is it with drive-by First Amendment lawyers not wanting to differentiate between free speech and defamation? Am I missing something as a non-American? No. Joral Navarro says, hey, Nick, since Arms Girl knew Illich, not Vic, was a pedo but chose to target Vic anyway, does that mean she had knowledge of the falsity like Jamie? Maybe. Maybe. Zero the Slayer says, some mega brain is yelling at me on Twitter because he's too scared to yell at you about the blackface thing. Like WTF, mate. Why is he scared to yell at me about the blackface thing? I'll talk about it. Well, I probably won't see it, to be fair, but you know, it happened. The thing happened. It's been described 100 times. Oh, by the way, I'm trying to line up Drexel for the 75K celebration stream. It seems only fitting since he's been a very popular guest on like the 50,000, 25,000, or 10 or whatever it was. So yeah, I'm talking with him about that. It would be later this month, as soon as we can get to the same place. So. Kalinka Pavlova says, Nick triggering my PTSD with these truth bombs. Hashtag I stand with Vic. Pessimism with salt for flavor says, greetings from Tucson. Have you seen the video of Sean Schimmel and Sonny Strait making pedo jokes in Vic's voice? I sent it to your .org email. Used a different email though. Cheers, bud. Yeah, I haven't actually watched the video. I'm not really concerned about that too much. They're not really in it. Although maybe it should be thrown in. But Funimation will say, well, we're not responsible for that. Scables says, can we have a minute of silence for those who were truly abused in any way, shape, or form? A minute's a long time, but a moment, sure. There you go. Cocky Onzai says, my sister, an actual assault victim from many years ago, would absolutely kick the snodge out of Jamie for this. And Dumfrey as well. Hashtag foots in arses. JCF Data says, thanks, Nick, for the streams. FYI, Mr. W Classroom up to $2,555. Hey, that's awesome. Thank you, guys. That's amazing. And it's still going up. You guys are fantastic. Rhino says, I'm taking a business law class for my BS and your channel has been very helpful. Officially designating your channel tax-free educational when. Well, that'd be an argument, wouldn't it? Serial Foxity says, clap from the casting couch. Medic. Narcticon DM says, Marquis queefs caused Hurricane Dorian. That'd be the butterfly effect to end all of reality. Nihilist says, I believe Jamie had a traumatic incident with Vic as much as I believe a woman in Gamergate days got PTSD from being on Twitter. Genevieve7 says, can I get a shout out for my brother Matt? He's a third-year law student in his first bench trial tomorrow prosecuting a traffic court case. Hey, good job, Matt. You go put that traffic court scumbag behind fines. No one important says, you for real? No HR at Funny and the other is his wife? I mean, there is HR at Funny. There's one person at Funimation who runs the HR department. I believe that's, what's her name? Oh, God, I can't remember. But she's also got an assistant for an organization with 315 people and well over $100 million. The HR department is one person. So there you go. Dracula Garfunkel says, wasn't Jay responsible for the unbelievably terrible depo of Alex Jones? I don't know. Maybe. Jared the Cat 88 says, you said 4 F-bombs, so I did 4 shots. Oh, good luck, buddy. Unicorn Meatman says, Renfamous has shared a post of someone who used Kiwi Farms to find Tug's face. Talk about being a hypocrite. Well, I mean, no one ever said she was consistent. Trina Simon. That's the person. Thank you. The HR at Funimation. SM Scorks 89 says, talk about Meyer's document, the one before Waid's. I did cover that one, didn't I? I thought I covered that. Yeah, not the I didn't cover the proposed scheduling order, but I downloaded the response to the motion filed by Richard Meyer. I'm pretty sure I actually covered it on a live stream as well. I'll go check, but I'm pretty sure I did. Trashfire Comics says, reminds me of Rose McGowan taking a 100K settlement from Weinstein to keep quiet, except Rial and Markey put all those women in danger for free. Official Rogue Ent says, blood pressure, Nick. You got that vein popping out. Good to know you got Vic's back. Love your streams. 2 days left till the truth is exposed. TLJ Screwjob says, Legend of Lemois, can't blow into my ocarina. Michael Ziada says, Nick, I love that you give the hard truths about stuff. I personally hate that Chris Sabat turns out to be crappy, but can't run from the truth. Me too, buddy. Alex Blackfoot says, am I out of touch? No, it's the fans who are wrong. Narcticon DM says, Fly 2, you killed my father, prepare to die. Mexican Man and Cheese says, hey, transcriber, make sure to get paid up front. Finfrog says, when Lemoyne loses this case, he can always fall back on his moonlighting as a consultation officer for Orkin. Anthony Siebert says, Fly, hello. Hello. My name is Inigo Montoya. You killed my father. Prepare to die. My name is Inigo Montoya. You killed my father. Prepare to die. Oh, he says brother. Dang it. Eric Weathers is from the letters of your boys Jawbreakers. Check out Flying Fortress letterer of your boys Jawbreakers. Check out Flying Fortress on Indiegogo, a World War II time travel adventure. Fazil Kolepe, thank you for the donation. I hope I pronounced your name somewhere close to true. Cam Freed. Yeah, of course. Cam Freed says, hey, Nick, loving the stream. It really helps when I'm drawing artwork. Can I shill for a minute and have you advertise that I do commissions? Email is hibachis.art@gmail.com. If anyone in the chat is interested, hibachis.art@gmail.com. So, yeah, thank you. Thank you very much. Let's see. So, Azil Kolepe says, watching all the way from South Africa. Hey, thanks, buddy. Welcome to it. Stay safe out there. Ben Frog says, Usher Zaid's part 50 of my motion to dismiss. Yeah, no kidding. Anthony Alaman says, hey, Nick, do you know what's going on with Alex Mason? No idea. Nothing at all. Killig says, have you seen the A&N article? We just did. It was put out a couple hours ago. Seems like they were throwing Schemmel under the bus. Bias as always, of course. I didn't get to the Schemmel part, but I'm not going to read their entire article. I was critical of the parts about that I read. Zypher Warrior says, if Mars Girl reached across state lines from California to Minnesota and slapped you across the face, where would the jurisdiction be for medical bills? Minnesota. She literally is reaching into the forum state. Now read Montoya's line in Lemoyne's voice.
My name is Inigo Montoya. You killed my brother. Prepare to die.
That was him doing the impression of Manny Patinkin. Hopefully that worked for you. Rolana 1 says, if Mark Waid does appeal, can't the Court of Appeals just throw out his appeal as he's clearly just trying to increase the cost? I mean, they can, but you still got to fight it. Snarkticon DM says, Mitt Romney with the binders again. Cosmic Drew says, before the 51 raid, we should raid Funny and find the Sabbath couch. Then we'll use it as evidence. Without the Sabbath couch, he will lose all of his power. Sakaki Onsai says, what the hell is up with the delivery of binders? Doesn't the judge and the clerk already have the copies? Jay Sean is really sucking up and failing. Yet you deliver a binder to provide a little bit of your narrative to it. You killed my lung. Prepare to die. Cesario says, Nick's into vodka. Dude, you're going to have a 404 error when you go to HawaiiCon. Tons of locally made vodka in Hawaii. Paniolo whiskey is my suggestion. Paniolo, you say? You talking about this one? Oh, we've got Paniolo, my friend. I did a distillery tour. I did the distillery tour at Paniolo. And at the Ocean Vodka Distillery. So... I am a fan. Let's see. Snarkticon DM says, you touched the fly and confessed on camera. Dope. Tucker says, Nick, I know you're a former gun owner. 9mm or 45 ACP handgun ammunition. 45. And then AR-15 or AK-47 rip boating accident. F for respect. I haven't fired an AK. My AR was a SIG 516 Patrolman. It was very nice, and I really, really liked it. So there's that. Cody Bayer says, check your Twitter DMs. I just sent you something you want to check out regarding Nadolny. Maybe you've seen it, but just in case. Oh, Maven Collectible Interviews. Yeah, it's the thing cited in the Anime News Network case. I'll have to give it a watch. Thanks, buddy. Thanks for sending me that. Let's see. What do we got? E says, can defense for different clients work together? They can. Yeah. It's not always advisable, but they can. Andre Felipe says, hello, Nick. What about the testimonies of the Kamehacon owner? Will they still be used in court? Yes. Unless the judge strikes an unsworn affidavit and he doesn't have a good reason to. So, if Vic wins TCPA, I hope he doesn't settle. Go all the way. We'll see. Austin Heartless says, I am Sham. Sham I am. Do you like green eggs and ham? Aisha Fraser says, now 28. Hey, congrats. Happy birthday. Can I get a birthday wish in your Vegeta voice?
I don't like doing birthdays. But happy birthday. Or something.
5, 7, and 2 says, got in late, an hour behind. Pro tip for the white knights, male feminists, and Me Too bandwagoners. You'll get the knife next. Just ask Alec Halauka. Finn Frog says, Volney the Snake confirmed. Lemoyne welcomes you to the club, you twat. Susan's Censorious Poop Waffle Network won't let me type words. Tism says, I'ma ask a girl out tomorrow. Wish me luck, chat. Good luck, buddy. Good luck. Yeah, it does kind of sound more like Piccolo. I'm sorry to fail you. Oh, dang it, I forgot. Oh, yeah. Boy You Knew When. Boyunuen says, wasn't Markey one of the VAs that boycotted KamehamehaCon along with the others to pressure the convention to drop Vic? Isn't that part of TI and Malice? No, I don't think she was invited to KamehamehaCon because if she had any role in Dragon Ball, it's very, very small. And then he also says, Boyunuen would be approximate way to say it. Thank you for helping me out with that. Ben Frog says, ANN Sabbath's little biatch. Of course they are. I'm guessing he's one of their regular inside sources. If I had to guess. Let's see. What do we got next? Danny31792 says, did you see what Alex Mason, Unreal Ent Gaming, said about Ty? He said Ty isn't doing his job and wasting time on your show. He took the video down. No, I didn't see it, but I don't care if he has that opinion. That's fine. Unreal's always in the chat hyping here. I mean, if he's got that opinion of Ty, that's fine. So, shockingly, I'm okay with people having contrary opinions to me. That's perfectly fine. Marky retweeted the boycott. Oh, did she? Oh, did she? Finn Frog says, ANN showing its long-edged hate boner for Vic. Well, you know what happens if ANN... I mean, if the story of someone else actually forcing women to have sex for roles at Funimation turns out to be true, and then Anime News Network went after Vic for literal hugs, I mean, that's just poetic, isn't it? That their investigative journalism went so deep that they got all the way to hugs in public, and then decided to ruin a guy, but they couldn't get to probably someone who has offered several comments to them in the past, actually being a sexual predator, a real one with real sex. That would be really embarrassing. And a drunk pretend attorney from Minnesota yelling at his microphone on YouTube was able to maybe uncover it before they were. God, that would be really, really embarrassing for them. Macca Jr. says, Lemoyne, the con sluts, send their regards. Nylox7 says, who was she dating? It wasn't a Chris Seabat. I don't know. Richard G says, hey, Racket, serious question. Could defendants still settle if the TCPA fails, or is that no longer an option? It's always an option if the plaintiff is up for it. That's between Ty, Vic, and the defendants. Colin says, Ready Player One. Dang, get those kids some Brandon Sanderson instead of that absolute disgrace of a book. Oh, I liked Ready Player One. Jeez. I mean, I thought the ending was a little bit too cheery, but it was fun. It's very, very rubbed my 80s nostalgia boner. Big Red Bear says, ask yourself this, Nick. Would the People's Republic of China donate to your friend's campaign? Were this the People's Republic of China, we'd never hear from your friend again. Hashtag books are a lie. Jordan Genesis says, Nick, the way Marchie used the no true Scotsman fallacy really rubbed me the wrong way. She should be ashamed of herself of using that. She was great as Rias Grimori, but now I lost respect for her. Let's see. Skeet Neat says, cheers for Terry Bogard for being confirmed for SSBU, Undertale, FAGS, GTFO. Sans Me costume is only in the game because the fan base are a bunch of babies. P.S. Undertale is a ripoff of Yume Nikki. Okay. I don't know anything about that other than my kids like Undertale. That's it. Ben Frog says, listen up, gumshoes. James Keene says, looking forward to the hearing outcome. Me too. Henry Aller says, favorite Hall & Oates song? Maneater. Tucker says, I worry about poor transcriber Kun. I hope he's being paid. Siren Jack says, hey, Nick, check my Twitter DM if you didn't see. Oh, thanks, buddy. I gotcha. Let me just say I'm working on a warm handoff on that one. Heinrich Berndowski says, thanks for the stream. What's your take on Alec Halauka's suicide? If you Google his cause of death, it automatically states it to be murder as of yesterday. I don't know. I haven't really looked into it. I've been so focused on Vic's case and getting ready for I got a big event this weekend that I'm going to, and hanging out with my kids and all of that stuff while I'm home. So Nathan Kish says, can any of the Wheezy One's dirty tactics thus far have any legal consequences on himself, censure, or whatever it's called? Yeah. I mean, they could. I don't think they will. I think Judge Chupp is going to say, enough of this nonsense. Let's get to the merits of the case. Let's see. My P.O. Box is P.O. Box 97, Spicer, Minnesota 56288. It's in the description of the video. Rick U 1186 says, Kick Vic talks big, but reality is always lacking. Zario JPN says, pronounced Paniolo whiskey. Paniolo. There you go. Paniolo. Satanic Potato says, in all of this, we forgot about the real victim in all of this. Shane's chair. Automata says, Hollow Notes, adult education is underrated. I'm not off the top of my head familiar with it. I think it's Oates. It's either Hall or Oates has like a landmark case in child support in Minnesota for some chickie impregnated while on tour here. Good job, buddy. I think it's Hall. Okay, let's see. Regal Beagle says, hey, Legal Eagles, it's time to think like a lawyer. Intimidator 0108 says, listening to you make fun of Mike while getting some decal design work done. As Richard Rawlings would say, let her rip, tater chip. Blaine Cooper, thanks for the mask. Jay donated and said, Marky's victimhood is an affront to actual victims. I'm inclined to agree. At least her victimhood in regards to Vic. I don't know if she's a victim of someone else. That would be unfortunate. Omnitraxia says, what power did Vic have? The power of love, which is a curious thing. These girls wanted him. He pumped and dumped and they got angry. It's been pretty clear to me from day one. I have no information about that, but I know that theory's been floated. Mercenary says, Nick, please stop the flaming rage before you set something on fire. And now you just set fire to Marietta and Camp Pendleton here in California. Can you be charged with arson for this after losing the case and tie his case again? I'm sure I can. You can ask Mike Dumford. I'm sure he'll provide you with a 700 tweet thread. Kay says, San Francisco voted to declare the NRA a domestic terrorism organization. Is there a potential class action defamation lawsuit that can be filed by NRA members? I'm pretty positive being called a terrorist by a city that is covered in homeless poop. Did the city council do it? Or did the city council do it? Or did the, whatchamacallit? Was it like citizens? That'd be a weird cause of action. But if it was done by government, then they might have a 1983 claim where they're attempting to use the color of law, labeling it a domestic terrorist organization to deprive them of, or to chill their speech, in effect depriving their First Amendment rights. That'd be kind of a stretch, novel argument, but you could make it, maybe. I need more info. Dash Rider Singh says, hey, Nick, have a CD release party in Minneapolis Saturday, September 14th. You should show up and I'll get you a drink or two. Well, email me. I don't know if I'll be in town that day or what's going on, but email me. Might be fun. Crusader Saracen says, the Zoe Quinn Alec Halauka situation made my best friend, who I intended to go into the anime game industry together to talk about what if one of us were Me Too'd. Without hesitation, we said we'd always have each other's backs. I thank God for him every day. Yep, you gotta have support. You gotta have support. Brass Knuckles says, what I've learned from this Vic case is that if I'm ever going to need a lawyer, I'm going to have to ask for their Twitter handle first. Felipe Move, thank you for the masks. Tower Gay says, anyone else notice how ANN leaves out in all their reporting that one of the defendants is a legally confirmed wife-beating piece of poop? Of course they do. Bad Dragonite says, the company I guard is like that, one or two people in HR for hundreds of employees. They heavily rely on us guards to help them keep track of people and stuff like that. Never seen the kind of poop show that is Funimation, though. Bad Dragonite says, Inquisitor Nick, I use a chainsword because my las guns are at the bottom of a lake, Rekieta. Finally, let me start the outro up. There we go. There's the outro. Austin Heartless says, so Green Eggs and Sham has the best chance winning at TCPA. Yeah, I think Marky has always had the best chance of winning at TCPA. Nothing has changed that. I think I put Funimation closer to her chances, but I think Funimation chances got worse and worse with their affidavits. But yeah, I think Marky's got the best shot. And I think if Judge Chupp wants to not rule entirely one way or another, that he throws out at least the TI claims on Marky and maybe the civil conspiracy claim, but he upholds the defamation claim. If he wants to split it, he doesn't have. I'm not saying that that's what he wants to do, but if he wants to split it, that's how I think he would split it. He may, if he upholds the conspiracy, he might have to uphold everything. We'll see, though. It all depends on what Ty brings to court. Then Tucker says, yes, the actual city council did declare the NRA a terrorist organization. Well, then they may be able to say that the NRA's rights were infringed by the city council. And I think maybe individual members might have, they can maybe raise cause of action for defamation. That's a weird flex. Again, a city doing a weird thing. Government has no business doing that, especially that branch of government. Grendai says, for the last time, it's ma'am. And Ron Toye's Yelp account says, I, Ronald, Giver Black Guys and Black Eyes Toye, give this channel 1 star out of 5. The host is a meanie, and the parking is terrible. I look forward to it being shut down, as I, the destroyer of businesses, have spoken. Got you now, Rekieta. No! Ron, why? Why you betray me? Why you betray me like this? Take a look at your buddy's GoFundMe. All right, it's great. You guys are awesome. I am, here, I'll pull it up one last time. We got $2,655. You guys are amazing. Thank you so much. You are directly helping kids through a very good guy. So these books will go a long way towards impacting them. So thank you. Thank you. Whoops. There we go. All right. Let's wrap up the show. Yes, I'll be on Twitch. I'll be on in a couple minutes. I just gotta, whatchamacallit. Go to the bathroom. That's what it is. All right, guys. I'll see you over there if you're coming. Otherwise, catch me either tomorrow or Friday or something. I'm not sure what the streaming schedule is going to look like. I'll announce it. Don't kill me. Sorry. Peace. Peace.